Introduce our newest member first, then we'll have the, please stand, it's all right. Gerald White. White is our newest member on the Planning and Zoning Commission. I'd like to introduce him to all of you all. Whatever. Pledge of allegiance. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one God, under God, indivisible, with liberty and justice for all. I don't know if y'all had the day I've had already.
Cool. Well, you're in for some more.
All right. First item on our agenda tonight is approval of the minutes of the last meeting. Are there any changes or notes? If not, I need a motion to approve as presented.
Move to adopt as presented.
Second.
Moved and seconded. All those in favor say aye.
Aye.
Opposed, like sign. We have two items on consent. The first item is Macho Products for a preliminary plat approval, and then we have Salt of the Earth Ministry, the request to use non-paved stabilized parking for a proposed church. Would anybody care to pull either item?
I make a motion we approve the consent agenda.
Second, to that.
Second.
We got a motion and a second. Both items on consent would be approved as published. All those in favor say aye.
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 Opposed, like sign. Tonight, item 4A has been pulled from the agenda. I think I haven't read the paper today. I'm sorry. I've been busy. I know we talked about it. We've notified people. If anybody's here for item 4A, it's not going to be talked about tonight.
You want to explain what 4A is?
That's the wild turkey sand mine, in case anybody did not know that.
I thought they'd all be gone by now.
If people are leaving, let's clear out as quickly as we can. We have a big crowd tonight.
Nice, George.
If anybody is here for the wild turkey request for major site plan approval and administrative permit use for a sand rock mine, the item has been pulled from the agenda tonight.
Point of order. Excuse me, sir, but isn't it that they're going to argue for a moratorium tonight which will not include wild turkey, and isn't that very similar?
It could be considered that, yes, ma'am. We'll get to that in just a second. I'm just letting you all know that that item has been pulled while the chamber is clearing. Next item on the agenda, that we have a public hearing. The first item is for a proposed moratorium for mines in agricultural areas. This has been asked for by the County Commission due to some consideration with agricultural residential areas. We're going to discuss this tonight. As a point of order, we're going to talk about the moratorium itself and not about specific land development regulations that you may want to have discussed in the future if they have a workshop or in a moratorium. Tonight is whether or not we have a moratorium or not. That's what we will be considering up here. As to the specifics as the wild turkey, that should not come up tonight. It's whether we have a moratorium or not. We'll see how that plays out. First, the way we're going to handle it is we're going to have comments from the staff. We're going to have questions from the commission to staff, and then we'll open this for public hearing. But first, we've asked Will Collins to go through some of the talking points that may occur and or the regulations and that might occur in something like a moratorium. Will?
Thank you, Mr. Chairman. On October 23rd, the board was considering the adoption of some regulations that affect mining, and in the process of going through that ordinance amendment, they had a substantial amount of input from people who lived in the vicinity of existing mines that were operating in the area of 82nd Avenue. And after hearing that input, the County Commission came to the conclusion that our regulations with respect to mining should be strengthened. There were issues of notice, perhaps changing from an administrative permit, which doesn't require a public hearing, to a special exception, which would involve notifying nearby property owners and possibly people living on designated haul routes. There were issues of traffic safety that they felt needed to be addressed. And because of that, the County Commission directed that a moratorium on mining ordinance be prepared. Normally, an ordinance can be adopted on 10 days' notice, but there's case law in Florida that states that a moratorium is at least as significant an event as a rezoning and thus should be adopted with the same formalities as a rezoning. And because county-initiated rezonings involving 10 acres or more require 2 advertised public hearings, we're going through the normal process. We have already presented this matter to the Professional Service Advisory Committee. It's here for a recommendation from this body tonight. There will be a public hearing before the county commissioners next Tuesday at 9 o'clock on the 18th, and at that time the board will determine when the second public hearing would be held. Normally that would be after 5 p.m. on a weekday unless the board by a supermajority vote decided to hold it at another time of day. That's essentially the process that we're going through. The Professional Service Advisory Committee considered this matter last week, and there were several motions. The first motion was to approve the moratorium, but accept from its operation 3 mining applications that were currently being processed. That motion died for a lack of a second. There was a second motion that if the county commissioners did approve the moratorium, that the 3 mining applications in process be accepted from its operation, and that motion ended in a tie vote 4-4, so that there was no motion passed. A third motion was to recommend not to adopt the mining moratorium, and that also ended into a 4-4 vote. I think it might be helpful to go through the substance of the ordinance. Right now, in Section 1 of the draft ordinance, it states that no applications for mining administrative permit approvals shall be accepted or processed, and no mining permit shall be issued until July 2008. And at this point, the intent is to have a 6-month moratorium to develop more effective regulations with respect to mining operations. There has been some discussion since this was drafted, and I should say that we drafted this as broadly as possible. It affects all the lands that are zoned Ag 1, Ag 2, and Ag 3 in the county, in the unincorporated area of the county. And there has been some discussion at prior board meetings that perhaps that area need not involve the entire county. There are pros and cons on that, but I'll leave that issue for you to debate. There also are no exceptions to this prohibition, and there has been some discussion among staff that there are certain things that you might want to consider for exception. There are a number of existing mines that are required to get an annual operating permit. So each year, any operating mine files an annual report of its progress and gets a renewal of its operating permit. There's the potential that that might be a category of exemption from the moratorium, or not. That's something up for discussion. The other thing that's been discussed are that sometimes there are requests for administrative approvals, which would involve changing haul routes or moving construction trailers on site, and whether those administrative approvals that are typically handled at a staff level should be allowed to proceed, or whether all mines should wait out the 6 months before they move forward with any new permitting. There's also been discussion, as was the subject of the Professional Service Advisory Committee, motions as to whether proper applications that are in place prior to the effective date of the moratorium should be processed and considered grandfathered in effect. And with that overview, I'd take your questions and toss it back to you.
Well, let me clarify some of that for our sake up here. With this ordinance, you're talking about making no exceptions for anything and any time, but you think that we should consider either exempting applications or exempting renewals?
I know that those are topics that are going to be presented to you. Our intent was to make the moratorium as broad as we could, because if you advertise a more limited moratorium or moratorium only on certain properties, you can't expand it later on without starting through the advertising and public hearing process again. So we intentionally wanted to make this as broad as possible, and if, based on the public input you hear, you think that there should be a narrower moratorium or exceptions to that, that's a recommendation that you can make.
Well, the thing I have wanted to be clear about is I don't want to talk about traffic and haul routes and hours tonight, I don't think. I mean,
no, that's really the point of having the moratorium, so you can maintain the status quo while you go through those workshops and identify the issues and what regulatory criteria would help to resolve those issues.
One issue that I'm curious about is if we move forward with a moratorium and we do this in the broad fashion, is there a method by which, when a renewal comes up or current mines, if we change the regulations and or bonding or traffic, for instance, if we change something, are we going to be able to retrofit all of these other mines? I mean, is that going to be from a day point forward? Is that legally possible?
I think it is. I mean, we'll have to work through that as we develop the ordinance, but if we've currently got a requirement that a mining permit be renewed, I think we can work in provisions that renewal of those permits would have to be in compliance with the then existing regulations. I know that in terms of subdivisions or land development permits, those approvals are typically good for 5 years, but if they're not utilized within that time frame and they have to come back, even though the development is intended to be substantially the same, we look at them under new regulations that have been adopted since they were originally approved. So I think we probably could impose whatever new regulations come out of this moratorium on operating permits of existing mines going forward.
Okay. All right, Commissioners, if you all, any questions of Will?
Staff or whomever. I thought that an annual report / renewal was standard for these mining operations. You acted as, I interpreted your statement as that it was a separate entity, could be separate. Bob, isn't it a?
Yes, mining permits are renewed annually.
By staff.
By staff. The applicant has to submit a status report of his mining activity telling us how much he mined and the status of his project, and we go out there and inspect it. But
and he has to
generally,
report to you if there are any new possible. I just gave the state ordinance to our esteemed attorney down there, so I just reviewed it. But I interpreted Will as saying that was something negotiable. We're not going to change that, are we?
Well, there are certain things when from year to year, things change. They may move from one phase to the other. A new phase may involve a different size mine or a different size phase. They may have to post new bonds depending on the acreage involved. So there is, I think, a fresh look each year at where they are, and if they need to make adjustments in the obligations they have to the county, that's typically done at that time.
But if they enlarge the mining, they have to come back for a whole new permit, right? They can't enlarge. It's good for X number of years, but okay. Thank you, Mr. Chairman.
I'd like to follow up on that question just a little bit further. Let's say, Will, we go to the extent where one of the items of discussion is for the mining operation to have to pave the road. If we decide in the new land development regulations that we want the roads paved and somebody comes in for renewal, can we actually, can they be forced to pave the road? Could we, I'm not sure how fair that is.
Well, I don't want to speculate too much because I don't know what the regulations will look like, but it's conceivable that we will look at the cumulative impacts of mines. There are currently 2 mines on 82nd Avenue. There's another one that's proposed, and if there was to be a paving requirement to come out of the moratorium, it would probably be equitable to have some proportionate contribution from each of the people that are contributing to the cumulative problem on the unpaved road and contribute toward a paving, whether it's through some kind of an assessment process or, we just don't know how it's going to go at this point, but we would certainly attempt to bring as many people as possible into the updated regulatory environment. Now, whether we can accomplish that totally, I can't guarantee that. I think you have to look at the facts and cases and what you're trying to apply to an existing mine, and it may vary on a case-by-case basis.
Well, in something like this down the road, if we looked at a moratorium and we do it countywide, we do quite a few mines inside the urban service area now. We use a mining permit when they dig a lake, residentials. Are we going to reclassify that? Are we still going to have, is that something we're going to look at? Are we going to call all this sand mining that's done now? Will there be a reclassification or?
Generally, within the urban service area, the only mining that's done is what's called incidental to construction. And that's because with a development project, you have some development projects that are net importers of fill and some that are net exporters of fill. Some need to bring in fill to raise their house pads. Some have more material than they need and have to get rid of it. An example is Waterway Village. They have an incidental to development mining permit, even though they're in the urban service area and they're zoned PD. We treat them just like a regular mine. They have to put up bonds, compliance bonds, road bonds, just like a regular mine does, and they have to adhere to the same regulations that mines do. So I'm assuming that if there are new regulations passed that affect mines and mining permits, the incidental to construction mining activities will also have to adhere to those.
Okay.
So the consideration for the moratorium involves operational mines as well as current applicants and future applicants for mining.
Well, it doesn't involve the existing mines except to the extent that they come in to annually renew their operating permit. If someone renewed their permit in the last 6 months, this probably will never touch them because they won't be up for their annual renewal until the moratorium is over. If someone needs to renew their operating permit in 2 months, then they could conceivably be delayed until the new regulations are in place. But that's a policy decision that's going to have to be made, and I'm sure there'll be a difference of opinion from.
Do we, within the criteria we're talking about, we have 3 mines that are applications in that are incomplete, but do we have any mines that we've approved that have not gotten all the permits that would be affected by this? That we've already backed up? I'm thinking 3, we had Fisher out on 82nd, then we have another one prior to that?
Yes, if I could, Stan Bowling, Planning Director. Let me just give you all a few numbers on the mines we have out there and so forth, just so that you get a little feel for it. There are 3 mining operations that are approved that are related to the State Road 60 widening west of I-95, pretty far out on State Road 60. And I kind of look at those as a separate category because they were specifically approved for that material to be used only for the State Road 60 widening. So there are 3 that are involved with that. There are 6 in the unincorporated area of the county that are currently operating. And by the way, the mining permits, there's an initial mining permit issued after site plan and administrative permit is approved and all the jurisdictional agency permits are collected and submitted to staff and they post their bonds. That could happen any time during the year, but when someone is in the renewal period, it's every September. So all the mining permits come due and are looked at in September and October, basically. So the 6 that are out there that are not related to State Road 60, they all come due. Their renewals come due in the September-October time frame. We have 2 mining operations that were approved in the county but have been annexed into the city of Sebastian within the last few years. I don't know if this moratorium affects existing mining operations in the city? I'm assuming not, but that's just something that you'd want to know, because mines occur in more than just the county. We have one that was approved in April. It was the last one that you all saw, the Fisher Mine off of 86th Avenue Southwest, south of Oslo Road, west of I-95. They've come through. I think they have every jurisdictional agency permit except their county stormwater permit, which is under review. And so they may be in a situation where they may be ready to get their mining permit within a few weeks or not. I really don't know, but they do not have their first mining permit yet. We have 3 applications in for mining operations, one being Wild Turkey, and then the other 2 being Cairns and Sandco. Those are both west of I-95, basically off of the Oslo Road area there. They are not as far along in their application process as Wild Turkey was, but they are submitted. They have been through at least an initial staff review.
From staff's perspective, then, are we dealing? Is this moratorium, the request on the moratorium? It started, I know, when we looked at changing the rules because of the ag residential areas where we were bumping into a potential sand mine next to what would have been an ag residential area, which was lots 5 acres, 10 acres, et cetera. Wild Turkey doesn't bump into them, for instance, but any mine that would not bump in, are we hitting a point where we're in the gray area between the urban service area and, say, ag 2 or 3? I mean, are we really talking about ag 1? Is that the area that seems to be the most contentious?
Most of the ranchette development involves 5-acre parcels, and that is the AG1 area. But we've also seen ranchette development in the A2 area, parts of it. The part west of I-95 off of Oslo Road, for instance, that's still within the Indian River Farms District. And we've seen 20-acre ranchettes west of I-95 out in large grove areas. We've had the one.
Past 20 miles.
Right. So you still have the ranchette possibilities in the 10-acre and the 20-acre areas.
Mr. Chairman? Well, I just gave the state ordinance to our attorney down there, our second attorney down there. Are we going to, my question giving to him, are we going to run into any state/county areas of propriety? I mean, we're going to step on anybody's toes in the state with this legislation, or this? It's pretty clear. The state legislation is pretty clear, and they differentiate between.
I just want to make sure which statute you're talking about, that we're on the same one.
This is the Florida Administrative Code dealing with the Department of Environmental Protection permitting. I don't think we would step on their toes with this moratorium.
They differentiate between sand mining and limestone mining, under which coquina falls. So are you happy with that?
Yeah.
What I showed you?
When we come to deciding what should be the content of anything that comes out of the moratorium, this is something we might have to look at that time. But as far as issuing a moratorium, it's well within the discretion of the county to do that.
Okay. That was a good answer.
There was also legislation that became effective this July that I think evolved out of an attempt last legislative session to look at phosphate mining. My understanding is that they didn't pass a lot of legislation, but they set up a strategic task force that was going to be looking at mining at a statewide level, and there's been some discussion as to whether the state might be looking at this task force with a thought to preempt all mining regulations at the state level. I don't know that for a fact. I'm going to be talking with the Florida Association of County Attorneys tomorrow to see who follow that legislation and that task force to try and find out where they're headed. But there is the possibility that if we adopt new regulations, this task force may have some legislative ideas otherwise that they want to impose on a statewide level.
Would it be fair to characterize then what we need to really consider tonight in the moratorium is whether or not a time duration, whether or not we want to do the entire county or we want to divide it into the current A1, A2, A3, whatever zones. We need to look at what any exemptions it may be forthcoming, whether they're current applications, previously approved applications, whether we want to let the staff do their general approvals on whether it's renewals and/or just permitting for like trailers or whatever exists in current mines. Is that would be staff type approvals, administrative approvals? And that's
correct.
In the staff's mind, and maybe the public will enlighten us, but that's the context I'm thinking in terms of. Now, I don't know about the other commissioners, but that's kind of the context, just as an overlay for tonight. So
Those are the hot potatoes.
I'd say they've got a few buttons on them. Okay. Any other questions of staff or?
One thing, just to follow up on what Will was talking about, the special task force, they do have a 3-day meeting next week.
Yeah.
And this is what we're discussing tonight is actually on their agenda. This is what they're having a problem with, communities like ours imposing moratoriums, and I think you're right, the state wants to regulate that. But after this task force meets, they're supposed to send a report to the governor by, February 1st. So should we be waiting?
If anyone has any better semantics than moratorium, we would entertain that as well. Okay. Anybody else?
Let's go for it.
All right. We're going to open the public hearing. What I'd like to do is I'm going to start over here on the right-hand side of the room, and with this section, then kind of work my way around the room. Everybody will have a fair shot. I'd like to, if possible, a couple of things. I'm not going to throw a time limit in this because I don't think that's necessarily fair, but I would appreciate it if redundancy begins, and I say you're being redundant, please give us some consideration up here, and let's try and hold this thing to not only civility and respect, but redundancy so we can all go home tonight. I'd like breakfast in the morning if it's all right.
2 days, right.
It's been a long day for some of us already. Okay. Public hearing is now open. We'll start with Mr. O'Hare.
I'm going to be very brief, George. My name is Michael O'Hare. I'm a lawyer. My firm represents homeowners associations, individuals, both homeowners and agricultural interests, who have an interest in this subject. And I'm going to suggest to you tonight, without getting into any of the details, and of course the cliche goes, the devil's in the details, without getting into those things, I'm going to suggest you really, I don't think, have an option but to adopt a moratorium, no matter what the semantics might be. You can call it something else, but things have to be held in abeyance. And I don't think it's any secret that what has prompted and been the impetus for your consideration of a moratorium tonight is, for the first time, in proximity to urbanized areas and developed areas, it's been suggested that rock mining, rock quarries, become a possibility. We're all accustomed to dirt mines. We've all seen them. We've all experienced them. Rock mining is something new entirely, and as Mr. Fletcher indicated and the attorneys confirmed, it's treated entirely different from sand mines under state regulations. I think there are geological factors, hydrological factors, considerations of traffic, considerations of dust, water problems. Just earlier this year, Judge Hoovler of the Federal District Court in Dade County revoked permits for rock mining that had been in place for 3 or 4 years because, unbeknownst to the public or to the judge, the public officials and the rock mining interests had, well, I won't say that this has been determined. The drinking water supplies of Dade counties had been contaminated with benzene, and that had not happened prior to the rock mining in the areas that were involved. And he was shocked to discover that. He revoked the existing permits. I think all of these things need to be in consideration, that factors that have never been looked for or looked at in this county in relation to mining as we think of it need to be reviewed and carefully reviewed. And a lot of information has to be gathered before you let any further expansion of mining or changes in the nature of mining, more important, in this county, to include lime rock and coquina, as it's called, need to be reviewed. And you need a lot of expertise and input before you can even begin to address the ordinances. And I would suggest that's going to take some time. I know there's legislation pending, and the legislature has a way of moving either at a glacial pace or of hip shooting. And I have no idea which approach is going to be taken to that sort of litigation. But I think you need to seriously consider, based on the input that you get, dealing with mining as you have with commercial and industrial development in the county, and designating zones, areas, where that sort of activity can take place without affecting aquifer recharge or traffic or geology, any number of these things. And it's going to take a lot of information and a lot of consideration. I don't have anything more than that to say. I urge you to go ahead and put a halt in place, if halt's a good word.
Mike, just a second.
I'd like to ask you a question, Mr. Hare. You mentioned the Thank you.
That's enough, or I'm going to start passing the plate.
And my family's not that big.
Mr. Hare, you mentioned the benzene as a pollutant. Is that just associated with mines that are using explosives?
There was evidence to that effect. The judge didn't find that, but he said it may be a factor.
So one thing that maybe we might look at is mines that use explosives, that anything that doesn't use explosives could be exempted. Is that something in your mind?
Donna, it's not in my mind specifically because, as I say, the judge did not actually find that. I've read his opinion. So it's not, he wasn't able to say that the benzene is attributable to the blasting that was used in the mining process. But he certainly thought it could have been a factor.
What you're saying, Mike, and Donna, I'm not trying to, is that you have, in order to, if we want the moratorium, we should support or go in favor of the moratorium for hydrological reasons. That's all.
That's right. You don't need to get into the details tonight, and I hope you don't.
Not. I hope.
But that's one of the things you have to consider, and that's part of the expertise you have to draw on to make a significant decision.
Thank you.
Certainly something they're going to look at, I think, later if this goes through. All right, Bob. Wait a minute, Davey. Bob Adair first. Oh, sorry. He's just a little slower than you are.
Yeah, he's further away.
My name is Robert Adair. I'm chairman of the Agricultural Advisory Committee, and I'd like to address some agricultural concerns to future excavations. And if we could show the, I have a brief slide presentation that if we could put that on the overhead. I just recently came across some information. Will you all advance them for me? I want to talk about the adverse impacts associated with non-mechanical dewatering caused by excavated pits. Basically, if you pump the pit, that would be a mechanical type removal of water. But there's other types of water that can happen that's non-mechanical. Next slide. First thing I would like to do is establish some definitions. We all know about the Floridan aquifer. That aquifer actually is categorized as a karst aquifer. It is a connection of passageways 300 to 500 feet below our county's land.
Is that David Cox in there?
That's a beautiful spring of what you can see on the surface. What we can't see is all the water that's flowing literally underneath this building and throughout our county, and possible perturbations to that important aquifer. Karst is best described as a region characterized by sinkholes, underwater streams, underground streams, caverns. These underground conduits are typically formed by acidic rain water that's basically water and carbon dioxide or carbonic acid that can dissolve the coquina or the limestone, which is calcium carbonate, and open up these passageways. And this has occurred over thousands and millions of years. These karst areas are typically devoid of surface water, as all the water is diverted through the underground channels. And then most importantly, our Floridan aquifer, where our county gets its water supply and agricultural users get theirs, and individual landowners outside the urban service area get theirs, is a karst aquifer. This may be a little bit difficult to see. I guess the salient points on this slide, if I could use the mouse. There's a confining bed right here. Above that is a shallow aquifer, typically going down to around 150 feet. At this confining bed right here isolates, or separates rather, the Floridan aquifer from the shallow aquifer. The Floridan aquifer begins at 300 to 600 feet in our county, and there are fissures between that confining area, but they're relatively minimal. Our county is divided into several regions. There's the Atlantic Coastal Ridge, typically along US 1, and then I-95 is built on what we call the 10-mile ridge, and then there's the Talbot Terrace that's west of Blue Cypress. The area where most of our agriculture occurs is primarily now west of 95 through Blue Cypress. Of ultimate concern to our county is the upper basin of the St. Johns River that's in this area right here, which is water supply for the St. Johns River Water Management District. Also potential surface water that could be used for utilities or potable water for our county that's yet to be developed and currently extensively being utilized by agriculture. Another way of looking at this aquifer, and this is very stylized, is we can only see what's on the surface, and as we start to create pits or excavations, we start getting close to these fissures, and the labyrinth and complexity of this aquifer actually moves up towards the surface. So there is interaction between the superficial aquifer and the Floridan aquifer. Basically, the information that I'd like to present to you this evening is a recent publication by a hydroecologist named Sydney Bacchus. She has published extensively in the area of hydroecology. She studied the Floridan aquifer system. She obtained her PhD at the University of Georgia. Her thesis title was Determining Sustainable Aquifer Yield, Ecological Impacts to Anthropogenic Groundwater Perturbations. I know that sounds pretty complicated, but the bottom line here is we're talking about a sustainable water supply and protecting that water supply.
Bob, if you can, is your concern hydrological and that dewatering affects, that if we have mining, it affects the water table, the water system? I mean, and to summarize this, I don't want to rush you ahead or anything, but if I doze off, I may forget to move on. So, I mean, I'm seriously, because with this, let me get too detailed tonight. Right. I hate to show my
quick concept is that when you remove water-bearing soil, as you can see in this cube on the left here, the amount of water that's in that area if you remove all the soil and aggregate particle matter, insoluble matter, you have roughly 1/5 of that volume. Mm-hmm. So you're removing that water, that soil. When you do that, you're lowering that water table by that amount, and that water has to come in. Here's the meat of this. Some of the adverse impacts from structural mining of superficial and underlying aquifer zones result from a lateral flow of groundwater into the excavated pit from surrounding areas due to the large void space of the pit compared to smaller void spaces filled with water in the aquifer. And that's what that diagram preceding showed. There's also a vertical flow or upward of groundwater that can happen through these fissures into the excavated pit from the underlying aquifer zones under pressure. via breaches, a leaky confined aquifer, if you will. Third, increased evaporative loss of water over the surface area of the excavation as groundwater is converted to surface water. 4, increased evapotranspiration, that's the water that's released through photosynthetic material, plants, surrounding the excavation as water-conserving native vegetation inevitably is replaced by water-depleting alien and nuisance plant species, Brazilian pepper, melaleuca, that type of thing. And lastly, contamination of the surrounding aquifer from pollutants entering the newly created surface water in the excavations. Okay, how does this all work? Basically, you can see the diagram at the top. Before the pit is dug, you have a recharge of 10 inches per year with a 54-inch, which is our annual rainfall in this region of Florida. When you dig the pit, you have evaporation greater than the amount of rainfall, resulting in a net loss. You also deplete the adjacent areas of the superficial aquifer. And this is the concern we have for agriculture and environmentally. And what happens is invasive species or rogue species that don't require as much water, like melaleuca or Brazilian pepper, can then invade those areas. What does this all boil down to? With a pit, you lose 19 inches of water per year for each acre. An example of what's happened in Lee County and Dade County near these pits, as you can see in this drawing here, is the melaleuca. Anybody that's been up and down 75 will have seen this type of landscape. This is an exotic species coming in because of the altered water tables. Another example is the native species then begin to die. Now, this is with excessive mines. Okay, so this is an intense excavations. You see these types of perturbations where you start seeing a loss of your native species. Okay, this is important. Extraction of the aquifer formations, regardless of material, results in 2 forms of permanent, irreversible, non-mechanical dewatering of the aquifer system and decline in water level. Basically, the first, it depends upon how much solids you pull out. The second is due to increased losses via evaporation and evapotranspiration throughout the surrounding pits. Neither forms of these dewatering, non-mechanical watering, is currently considered by federal, state, or local regulatory agencies during evaluations of applications for this type of structural mining. That means St. Johns River Water Management District is looking at these pits as a storage for water. This hydroecologist is showing they're a net loss. That's the point. The regulatory agencies are behind on this. You need further.
You're in favor of the moratorium? Is that what I gather?
I'm saying that this is up to me. If you're in favor of your agriculture in your county and you want to protect your water supply, you need to get the science behind this. And these adverse impacts associated with this types of dewatering represent an irrevocable loss of resources that are not evaluated or are accounted for by the regulatory process. That's a big concern. And these impacts result in significant harm to the human environment, our water supply, and federally endangered species with habitat dependent on the integrity of the regional aquifer system. And that's the final summary and conclusion of this paper. I've given all the documents to Stan, and I suggest they be distributed to not only the P&Z, but also to the Board of County Commissioners. Thank you very much.
Thank you, Bob. Bob, we have a question. Don't go anywhere.
Yeah, you're not going to get off that easy.
You're describing non-mechanical. What about mechanical means of dewatering?
That is, as I understand it, most of your mines are closed systems. They're pumping water out, going into a second pit. So there's no off-site movement of water. Anytime there's off-site movement of water, you basically that just can't happen because of the EPA Clean Water Act. By the way, we just recently met at the Soil and Water Conservation District Board, advising both your committee and the Board of County Commissioners to only approve closed systems, not to dewater and remove it to the drainage system and ultimately to the lagoon.
Bob, I've got a question for you, too. In fairness, and I appreciate the information that you provided, but in fairness, doesn't the conditions of the excavation, in effect, rim ditches, settling ponds, rate of pump, et cetera, don't those affect the conditions that you are indicating here as far as lateral flow, et cetera?
Yes. Agriculture does impact this hydroecology. There's no doubt about that. The pre-existing systems, is that what you're asking? Our network of ditches and drainage canals, yes, but they're only going 6 feet, 4 feet. They're very shallow. These pits are going deeper into the superficial aquifer, and that's the concern. Am I answering your question?
Well, I was speaking more specifically about the mining process and an individual mine, and the conditions and the allowances of that excavation as far as the use of rim ditches in that specific area and pumping rates and settling ponds, et cetera, have an effect on how much the environment is affected in that area. Isn't that correct?
That's correct.
Okay.
And the greater the area, the greater the evaporation. And that's the thing that's not being taken into account. And that's why I say we need further study.
Mr. Adair, do I understand you to say that in the mining operation where you dig the pit, you pump the water out into the ditch that surrounds the pit, does not cause a problem with the hydrology? It's just if it's going into the canal and then going into the lagoon is when there's a problem.
Well, there's two different issues, okay? One is the water quality leaving, and that's not allowed, as I understand it. That water being there by the fact that it's being dug out is in fact causing a problem, whether there's a perimeter ditch or a rim ditch or the excavation site itself.
And the problem is the water quality, you're saying?
The problem, in addition to the water quality, is the net loss of your water table to the adjacent areas to the pit.
Due to evaporation?
Due to evapotranspiration and evaporation, to say nothing of the contamination aspect.
Which is higher than the recharge.
That's correct. That's correct.
I understand that a lot of these wells these pits have wells around them that are monitored. I assume the monitoring of wells around the pit is to react quickly if there's any problems with the hydrology. I'm not sure what problems do you foresee that could not be monitored via the wells?
I'm telling you that in Dade County, they saw effects to the Everglades from the mining. Hydrological effects, dewatering effects, loss of water table, drying up of wetlands. In Lee County, the same type of effects were observed. I'm saying that you need the proper regulations to space these, the proper way to monitor these, and somebody that's a hydroecologist and not a research chemist for agriculture to explain those intricate details to you. So I'm at my limit in my knowledge on that. What I'm offering you is a scientist, a professional scientist that's capable of doing that was hired by those two areas to study those. In fact, in this paper, Dr. Backus studied 4 different regions in the state of Florida, and I'll provide you with that paper and her bibliography, digitally and hard copy.
Okay, and thank you. Any other questions with regard?
Dr. Bob, one of the things that's going to come up, hi.
Hello.
One of the things that's going to come up, first question is going to be, should we limit, under the limitations that some people are going to want, should we just limit the depths of the mines? I'm being the devil's advocate because I know that question's good, right?
That's going to be the first.
I think the deeper you go, the more dangerous it gets. But I really think that you need a professional to give you those opinions in that area.
Okay.
Thank you.
Thank you, Bob. Deevee? Is Deevee here?
He just walked out.
He just walked out. All right. Come on up, David.
My name is David Knight, 80 Royal Palm Point, Vero Beach. This will only take about 30 minutes. Only kidding. I encourage you to move forward with the approval of moratorium, but I think that the draft moratorium that you've got is rather limited in just the notice and traffic being the only two issues. I think we've heard in public meetings that we have public health, safety, welfare, compatibility, type of approval mechanisms, whether administrative or PD is appropriate, best management practices, policing operations, integration of the mines with a master plan or what is going to happen afterwards. Traffic improvements is on the list. Health issues, location, environmental, hydrological assessments, and what type of reports, what kind of protocol for those reports, who's reviewing those reports. We need to address all these concerns, not just notice and traffic. And I encourage you to broaden the scope of your considerations outlined in the draft moratorium to move forward with recommendations for approval so that both the community will know they're protected and the mining operators will know how they can proceed. Thanks.
Thank you, Dave. Dr. Cox.
Thank you, Commissioner. Thank you, all you commissioners. I'm certainly glad you're sitting there and I'm standing here. I have only one thing that I want to say this evening, and that's to remind you about a prior situation where we had some difficulties out in the ag areas where we invoked a moratorium. Unfortunately, then we did, in fact, call it that. And, George, I think you'll remember it. We had some people who really wanted to build a large telecommunication tower next to Sandy Kale's preschool. And this was in 2002, I believe. And we had the dark suits come down from Washington and tell us that we had to do this, that we had no local control over this issue whatsoever. We had to do it. I think you remember, Ms. Keyes, some of you may remember this event, and we skated on some pretty thin ice. We said no because we had a strong belief that the public health, safety, and welfare was of utmost importance to us. And we said no, but we were not arrogant. We said no, but we're going to have a countywide telecommunications master plan. We're going to develop this plan. We're going to decide where we can site things and what we can do. Now, this pause, if you will, did run on for a little while. I don't remember. I think it might have been, can anybody fill me in, 2 years? I think it might have been, maybe. It took a little while. But we actually came out of it. Now, if you drive down 95 and you come out of Brevard County, and in any place in Brevard County you care to look on either side of 95, you can see 7 cell towers at any given spot. You cross over into our county, you don't see that. You don't have that kind of visual pollution. And now I may suffer because I don't happen to have any cell at my home, but you know, we actually have a plan, and we drew a bright line in the sand, and we said, I'm sorry, right now, not tomorrow, not the next project that comes, but this project triggers it, and we are going to say no. So the precedent has been established. You can do it, and you can garner community support for your action. And we can come out of this with a lot of consensus if we use the time for this pause to construct a master plan, to think about it. That's all I got to say.
Thank you, David.
Thank you very much for your time.
Anyone else over in the paid seats?
Jens Tripson, Vero Beach. I'm representing Pelican Island Audubon Society, and I would like to urge you to adopt this moratorium and let us work it out in workshops of the breadth and scope of it. I would like to say from firsthand experience with 2 mines on our former property, the hydrological effects are deleterious. The second one, we had native species of trees die. We had to increase watering of the landscape material that we had planted in the ground. That was on a 9-acre mine. On a 16-acre mine, I had to then put microjet on 66 acres of trees because there was not enough groundwater under those trees to keep them alive, not just in drought, but all year. Because of the depth of the mine pulling the water littorally into the mine and taking it away from the trees. So please adopt or vote for the moratorium. Thank you.
Anybody else? Yes, ma'am.
Let's get him at the second podium, too.
Good evening. My name is Amy Banov. I live on 69th Street. I live in the vicinity of 2 existing mines, and my first comment is that this is not a new issue. Members of the areas around these mines that are in that area have had correspondence with the county for a long time regarding the adverse effects of mining in ag zoning. I'm a licensed architect, so I'm very familiar with code issues and property rights and design decisions that have to be based on the decisions you make during that process. But the overriding element of design decision is health, safety, and welfare. Anybody that's been on the beach the past week knows that you don't have to see particles in the air to know that they're affecting your health. And it's not just the trucks on the street, but it's also the operations of these mines themselves. The safety issues of the trucks on the streets is only one element as well. It's not just maintenance. This is not going to be just an occasional agricultural vehicle or a tractor. These are going to be trucks all day, every day, for years to come. And finally, welfare. We just spent a lot of money to buy some conservation lands out there to protect the future welfare of this county and the citizens in it, to have open space and open land and conservation efforts, and I applaud the county for doing that. Now you have to protect the welfare of the citizens by making sure that we don't make stupid decisions for the future. Our zoning regulations don't protect the health, safety, and welfare by allowing mines in ag zoning where there are residences nearby. I highly encourage you to put a moratorium so that you can discuss this. Get the people with the scientific knowledge to be up here and tell you the way to make it right, so we're not like every other county in Florida. Thank you.
John?
Mr. Chairman, members of the Commission, my name is John Higgs. I'm Chairman of the Indian River Neighborhood Association. In the preliminary remarks from the dais this afternoon, it was said that Wild Turkey Mine is a matter of concern to some neighbors. That is true, but that's not the reason this room is full. This room is full because there are many people who are interested in preserving our way of life in Indian River County. They're interested in agriculture being viable in the future. They're interested in adequate water supply for the future. And they're interested in our environment together. That is why the IRNA is interested. I'd like to make very few specific points. First, let's talk about moratoria, I guess. By their very nature, almost all moratoriums come up because a problem has been presented. They come up because something unexpected has happened which people believe was not correctly anticipated in the statutes that are on the book. That's why they all come up. They're all, in essence, emergency-type situations, and this one is too, and there's nothing unusual about this. Second point, there is absolutely no doubt that the county has the legal authority to make a moratorium of a reasonable period of time in order for it to study what the law should be going forward. There is no question about that, and do not let anyone tell you otherwise. There is also no question that a person who has submitted a permit application has no legal right to that application. Nothing could be clearer. The P&Z in the past has done a lot of work trying to come up with restrictions and what have you that would make mining applications in this very area viable. At least in my opinion, and I'm sure in the opinion of many people in this room, your efforts were not satisfactory. Only today I heard that the assessor is substantially reducing the assessed values of houses near the Quail Valley Country Club. Now that's costing me money and it's costing everyone in this room money. And it's not because you didn't do your job right, it's because the laws that you were working with at the time were not adequate. That's why we need a moratorium. You need a moratorium to look at the circumstances that have been changed since these regulations and laws were adopted many years ago. We all know that some of the finest residential neighborhoods in the entire county have been established in this area. When at the time the existing laws were written, no one had a clue that that might happen. We have to look at it. We have to decide in light of today's circumstances what is appropriate. In that context, I would urge that the moratorium apply to Ag 2 and Ag 3 as well as Ag 1, although surely the regulations shouldn't be the same for the three. We should look at it because this is the time that you and members of the county commission, with the help of people, of members of the public, can look at all of these and try to figure out what makes sense going forward. The matter before you is a 6-month moratorium. The Wild Turkey Mine says it will last for 10 years. Think about that. It's worth 6 months or possibly a couple months longer to look at the situation and decide what's good, because decisions made now will affect the county and our way of life for years to come. I believe the moratorium must apply to existing applications. There's no question about you have the legal right to do that, and there's no question about that's the reason that the interest is now so great. So I urge you to recommend to the County Commission that you adopt a moratorium that applies to all 3 agricultural areas and that applies to existing applications. Thank you very much.
Thank you, John. All right, would anybody else on the right over here? Mr. Knight, you came back to speak after the other night.
Thank you, Mr. Chairman, fellow commissioners there. I'm Victor Knight, better known as DV. Thanks to Mr. Higgs, my remarks are even more brief than they would have been before, so I will not be redundant.
That is acceptable.
My family's been here going back 110 years. I'm a 3rd-generation local, and in the course of my lifetime experience in Indian River County, I've seen a lot of situations that became a catalyst for change, or a lightning rod, if you will. And the Wild Turkey Project has become that lightning rod. I think the chairman will recall when back 35 years ago, 40 years ago, when I think it's called the Village Spires, the two twin towers on the beach, those were erected, and thanks to Art Neuberger and other city fathers, they recognized through extreme public output and outcry that we don't want any more of that. Well, it got into a big hullabaloo just like this. And thank God they did that, because if you're down south, the sun doesn't come up till 11 o'clock. This situation really is not that much different. It is the poster child today, and the reason that all of these folks are here, and it's a shame that we can't really talk specifically about that, and I won't. But I will tell you that I'm very concerned, as we all need to be concerned, about the changes in the legislature, the Florida laws that are coming forward, that if they take your right to permit these mines away from you and take it and invest it in Tallahassee. Let me just tell you what happened a few weeks ago. Now, you may think that this is just coincidental or whatever. Some of you know that we've got a 40-acre cattle ranch downtown on 41st Street and Indian River Boulevard, right across from Grand Harbor and in the hospital district. And I got a call some weeks ago by a rock consultant representing Rinker. He had seen the piles of cap rock that we have on the property and wanted to do some test borings. And I said, no, sir, I'm not interested. We've got a project that we're trying to bring forward. And he said, you don't know how much money you can make on that property, son. And I said, well, I really don't care. That's not going to be my lasting legacy in the community, is leave a big hole in the ground down there. And plus, you're never going to get it permitted. He said, we can get anything permitted. Now, that kind of arrogance, now I wasn't talking to Rinker, I was talking to their representative, their broker or whatever. He was quite insistent, and I terminated the conversation. But the point is, if they prevail in Tallahassee and they are allowed to permit these rascals out of here, we're going to have some real problems. And I think that the moratorium is essential, that it get imposed, and then we can look at our land development regulations and determine where this kind of activity is appropriate. Because surely where the poster child is looking to go, it is not compatible with the area. The health, safety, and welfare of a whole lot of people is at stake, in addition to the water supply and a lot of other things. I won't get into that. But, you know, in the LDRs today, there is no notification process whatsoever of adjacent landowners. That's wrong. If they're going to rezone your property right next door to you, you get a notice and you find out what's going to go on. And that at the very minimum. There's probably a lot of other things, but you need to have a timeout so that you can address where it's going to go, which district it's going to go in, and in what kind of criteria you're going to impose upon them. So you really shouldn't have any exemptions in this moratorium either. Otherwise, that poster child cow is going to be out of the barn. And then you're really going to have, we are really going to have a problem. I appreciate your time, and I appreciate the deliberations y'all are going through, but I urge you to pass this moratorium and save us all a lot of grief in the future. Thank you.
Just a second. Anybody in the center that wants to speak, we're going to change the rules, because we're going to let this half come to this podium and this half come to this podium. We'll try and get a little speed up a little bit, if you don't mind. So anybody from this side over, one at a time, will come up here. If there's somebody on the other half that wishes to speak, please come to this other podium to begin with. First to the right. Oh my gosh. And then to the left. Yes, sir. Go.
Good evening, Commissioners, staff. My name is Ital Varone. I live in Indian River Shores. I have been watching this project. I'm not an expert on rock mining, but many of us in this community, for many reasons, have become much more enlightened. And some of what I'm reading and hearing really is frightening with regard to our future. That's the reason that I'm here tonight. But there is one thing that I think I might add that I think is very important in the timing of this, of your adoption or your hopeful adoption of the moratorium. And that is that I believe that our planning staff is currently reviewing the comprehensive plan. Now, it seems to me if we have an 820-acre operation or something like that in the Wild Turkey Project, and we say to the staff, okay, this is fixed, this you're going to have to work around, it's a terrible compromise to what that comprehensive plan may come to be. And the comprehensive plan, I think, has a life of 6 or is it 10 years? Which is it? Between 8 years. So I believe you should allow the staff to develop that comprehensive plan totally unfettered. Now, one thing with regard to the moratorium that I will mention. Years ago, about 2003, there was a proposed interim moratorium. It wasn't a different kind of moratorium. It was on growth, on housing. And there were public hearings, and they were very well attended, almost like this evening. Caroline Ginn was the chairman of the county commission at the time, and she was the proposer of this interim moratorium. It was voted down, not by the sitting commission today, but by the earlier commission. And when it was, lots of things happened in this county. Some of them, I believe, at least I think, were not appropriate for this county. We had major national developers come in and take away opportunities from local developers. We saw them buy concurrency. We saw them advancing the state of the art. We saw them bringing in their own labor, all things that I thought might better be kept at home. Did it happen anywhere else? Yes. In Martin County, earlier than 2003, they adopted a moratorium. That moratorium was put in place, and the result of that can be seen today. If you look at unemployment rates, if you look at housing inventory, etc., Martin County always stands head and shoulders above Indian River County. So my hope is, and I urge you to please adopt this moratorium for just 6 months. Thank you so much.
Thank you, Tom. Okay.
Good evening. My name is Nancy Wood, and I'm here to represent the Indian River Green Team. I want to thank you for this opportunity to speak to you, and I will make sure that I am brief because there's a lot to be discussed tonight. First of all, I just wanted you to take a look around and see how many people are here tonight. See what a special community we have in Indian River County, that we really do have a beautiful piece of Florida, and we want to keep it that way. And that's why there are so many of us that came out this evening. There would have been more out here this evening if it wasn't for the front page story that this was going to be pulled. And as the officials that you are, I know that in your hearts you want to do what's best for the community. And I think this is a great observation of what the community wants this evening. So very briefly, I'm here to make a few points, and then I'll sit down and let the other people who have some very valuable information to share with you this evening. I wanted to ask you to definitely go with this moratorium. In my opinion, personally, I think that it should be put beyond 6 months, because when things happen in the summer in our community, there's a lot of people that just aren't here. And you can see by the people that are here this evening that it will be more productive and more proactive if we do it in the season where we have our higher population. So as far as that goes, I would like to see a year's moratorium, not just 6 months, but that's just me. Apparently, I guess it's not just me.
If we can get $1 a clap, around here, the county can. Some of us could retire anyway.
Well, we really are making a statement. We live here. This is our home. This is our home, and we want to keep it nice.
I appreciate that, Nancy, but we do have a lot to go, and we don't need to be quite as with as many outbursts if we don't mind.
Oh, I apologize profusely. The other mentions, I only have 6 topics, and I'm just going to briefly mention them. I would also hope that you broaden the scope of the moratorium about all the existing applications and the ones that will be in the future. I would like to see that taken into consideration. Yes, Mr.
Could you
Hamner?
explain that?
As part of the existing applications, I understand, and I'm not an attorney, so I'm sure I could be easily corrected. But as far as things being grandfathered in, if there was an application that was already submitted, like perhaps this one
Okay, I'm
about Wild
sorry.
Turkey.
Okay.
Okay, that's what I'm referring to. Also, the public health, safety, and welfare, I think that's obvious that we're all very concerned about that. And in the positions that you hold here, we're looking to you for guidance and direction. And I hope that you, and I feel confident that you'll be able to appease us. Also, I was wondering, when I heard about the renewal system for the applications that are all done in September and October, I would think that it would be more productive to do them as they come due every year so that you're not swamped with everything at one time. And again, this is kind of a dead season. It's the end of hurricane season, and it's kind of a tough time to get things done in this community. And I also thought that another reason to substantiate my claim that I think it should be past July is that when you think about that this could be in effect for at least 10 years, that maybe we should think about it a little bit longer than that. I think it's a valid point, and I think we need to address it. Also, the comprehensive plan is something that we really have to look at, and that we have to take into consideration the big picture and the future of our community. And finally, I just wanted to know about if you had any thoughts about when the workshop might happen, because oftentimes this is the political correct way to follow protocol to have it, but sometimes these things are ill-timed and they lose the steam that they need to be able to move ahead. So I would hope that any workshops would be done in this season, in the winter season, and also that this would be extended to at least a year's time. Thank you very much.
Okay, yes, ma'am, over here. Anybody on this side come up behind Nancy? Okay. Yes, ma'am.
Good evening. My name is Linda Mitchell. I live on 65th Street in the Two Bridges Equestrian Community, and I would like to just offer a non-scientific, non-political, but very sincere, very different perspective on this. I'm very disappointed to hear the impatience and the questions that have come up in terms of whether this moratorium should happen or not. I wasn't expecting that because, to me, I'm a licensed physical therapist. In our Practice Act, the most important words are do no harm. Everything stems from that. And to me, that is the responsibility of this council and this board and everyone who has the opportunity to make decisions. To put something on hold for a short time is not going to hurt or kill anybody. To allow something to go forward with all of the evidence that has come forward, and I know from all the emails and all the people that are here that you are aware of a lot of evidence that has come up and a lot of concerns and questions. Where is the harm in saying, let's wait and let's investigate? You can always go back and approve what's being asked for. And to do no harm is what I ask of you. Thank you.
Thank you, ma'am. Mr. Paladin.
Good evening, Mr. Chairman, ladies and gentlemen, commissioners. I'm against the moratorium. I think that a moratorium at this time or almost any time is a negative impact on the economy in this county. We really can't afford that. Now, having said I'm against the moratorium, I'm absolutely for proceeding with any policy changes or any input that would make the mining LDRs or policies better for the people in the county. But I don't think a moratorium is the way to do it. I think a moratorium gives you a false sense of security that actually something is going to happen or not happen. And I think that time would be better spent working on LDR changes together, improvising more policy changes that would be positive. And looking back, only about less than 90 days ago, maybe 60 days ago, we just put into effect some new LDRs and policy changes in the Chapter 934, the mining chapter. We barely had a chance to even impose those on any of the new mining applications coming forth. I mean, so we just reviewed that. We just brought it back. We just made changes. Now to say we have an emergency situation where we need a moratorium, I just don't see the reasoning behind that. I don't think that's a positive aspect to go, and I don't think that's a positive word for us to use with the way it is out there. I mean, there's people out there that don't have jobs. There's people out there that are going out of business. I think we need every positive aspect we can to keep business going. I have one brief legal question, and I'm not going to elaborate on it because we have several attorneys out here who are more qualified than me, but I'm going to ask the question anyway. Mr. Attorney George Glenn, was the state statute you were speaking of or in reference to Chapter 337?
No. I didn't bring it with me. I don't know if Will Collins brought it. Did you?
I've got a copy of 337, yeah.
Was that what Commissioner Fletcher was speaking of when he spoke?
No, mine was in the 600 series.
Okay. Well, on Chapter 337, and I'll be brief, under local government decision-making, and I'm just going to read a short paragraph here. No local government shall approve or deny a proposed land use zoning change, comprehensive plan amendment, land use permit, ordinance, or ordering regarding construction aggregate materials without considering any information provided by the Department of Transportation regarding the effects such change, amendment, permit, decision, ordinances, or order would have on the availability, transportation, and the potential extraction of construction aggregate materials on the local area. Now, reading that paragraph, have we talked to the Department of Transportation?
We're in the process of trying to contact them at this point.
That paragraph seems to be fairly clear, and that leads me to the point I made a little bit earlier. Getting involved with moratoriums, getting involved in legal issues is a waste of everybody's intelligence, time, and money. I would really like to see that time put together as a group. You know, the only way in this county we've ever achieved anything is when we all work together and made big changes in this county for the better. And I think that's the way to do it now. I don't think that a moratorium is going to achieve that. I think changes will achieve that. And I think we're going to waste a lot of time and legal fees and a lot of legal time and people investing their intelligence in trying to do something that's not going to come out with a positive outcome. So my advice would be to work together, go forward, and try and add policy changes as we impose the ones we just put into play 60 days ago. And as we go forward, don't forget these permits come up for renewal every year. And staff has all the input in the world as to whether they renew those permits. And a lot of the mining procedures now are state-of-the-art compared to what they were years ago when Mr. Tripson did his properties or other people did their properties. A lot of the old mining techniques of off-site dewatering stuff just isn't even allowed. But there's a lot of state-of-the-art processes that we can put into play that will benefit us and benefit our water supply. You look at the future water supply. One of the things for future water supply, alternative water supply, other than desalinization, which has proved to be very costly, is surface water storage. So, I mean, there's something to be said about that. There's a lot of studies to be done. There's a lot of information to bring forth. But I don't think we should waste our time fighting the moratorium. Thank you very much, sir.
Thank you. Yes, ma'am. Anyone else want to come up over here who wants to speak next after her?
That's why I was... Good evening, Mr. Chairman and fellow planning and zoning commissioners. My name is Susan Boyd.
Susan.
Is there some? Yeah.
These are designed for about
Okay.
8.
Is that better?
Sound much better
I do.
if you stand
Okay,
up
thank
straight
you.
and talk.
All right. I appreciate your time. I had a hard day today, too. I get up at 6 in the morning and I work all day, but I thought it was important enough to be here tonight. I understand the difference between a proposed moratorium or arguing against one particular mine. But, Mr. Chairman, it was you yourself who did mention that you might recommend that the Wild Turkey Mine would not be included in this moratorium. Therefore, I think mentioning the Wild Turkey Mine is very germane, because I would ask you and your fellow board members, if you do a moratorium, to make sure that you do include in that moratorium the Wild Turkey Mine. I do not think the time spent on discussing this issue during a moratorium time would be wasted intelligence or anything else. I think that people have gotten up here and quite ably stated that we need to look at the ramifications of these situations, particularly because this one came as such a surprise to so many of us. And it is changing the rules of the game because we're going from a sand mine to a rock mine. And it's my understanding they're quite different. But I would like to read my prepared remarks. They are very short, and I think I'm going to make a different point than other people have made tonight. When I read the Press Journal, front page headline a few days ago, quoting Mr. Sanders, calling the wild turkey mine issue political, at first I was upset that to him this was a political issue, not understanding that to the residents it's a quality of life issue. To the residents, politics has nothing to do with it. But then I thought about it a little longer and realized that yes, indeed, it is a political issue. In fact, it is the most fundamental of all political issues because it is about we, the people. It is about why we, the people, submit to government and allow government. The government's one overriding purpose is to protect us. We give up our taxes and some of our freedoms with the expectation that government will protect us and guard our inalienable rights to life, liberty, and the pursuit of happiness. James Madison in the Federalist Papers, arguing for the adoption of our Constitution, put it aptly, that if men were angels, no government would be necessary. We all know that we are not angels, so we have given the government the power to regulate business, property uses, and many other things in order to ensure domestic justice and domestic tranquility, in order to provide for the common good and promote the general welfare. These are lofty goals that we, the people, have set for our government. Usually we think of them in lofty situations, but most often it is the local, small issues in the general scheme of things that affect our lives the most. The proposed wild turkey mine is one such issue. It is my understanding that a rock mine will have many nasty consequences to the areas surrounding it. Perhaps nasty consequences can be overlooked or mitigated if the mine were located in a far distant area. This proposed mine, however, is located within a residential area and next to protected agricultural land. Is the government protecting us if it allows an operation that contaminates groundwater? The mine operation will be noisy enough that from 7 in the morning until 6 at night, my neighborhood will no longer enjoy peace and quiet. There will be constant noise of breaking rock, 200 dump trucks driving back and forth along a 2-lane, once sleepy residential street. 200 trucks for 10 hours a day will pass a given point, say the end of my street, once every 1.5 minutes. Noise is loathsome enough, but my research has shown that feeling the vibrations of the mining operation is a distinct possibility. Can any of you imagine what it might be like to live with the noise and vibrations for 10 years? Add to this 2 or 3 years of widening State Route 60 at the intersection of 82nd Avenue. Even if 82nd Avenue were paved, dust from the mine alone will permeate the air and exacerbate the breathing problems of many nearby residents. One can only speculate, but I do not think it is a wild accusation to say that if this operation were to go forward, it would hasten the deaths of elderly residents in my neighborhood. I know some of you are thinking, well, doesn't the Constitution protect my property rights? Yes, it does. But what it doesn't do is guarantee your right to make a fortune off of your property. If you buy property for an investment or speculation, that is exactly what it is, speculation. You have the right to pursue making money, and that pursuit is aided by our free enterprise system, but the Constitution does not guarantee that you will make money. That is the risk you take. When I invest in stocks for my retirement, I hope they will increase in value, but no one, especially the government, guarantees I will make money. Why is land any different? Unless one is a farmer or a rancher, one wouldn't buy land where that mine is proposed. The only other reason to buy land, that land is an investment, to develop it or mine it. The success of investment is not guaranteed in the Constitution, only your right to invest. What the courts have always held up is that government has the right to regulate the uses of property, and this is done for the welfare of the community as a whole. That is precisely why we ask our government tonight, promote the general welfare, provide for the common good, ensure domestic tranquility and justice by protecting our health, safety, and welfare. Say no to the wild turkey mine and declare a moratorium on all such uses of ag land. Thank you.
serious now. We're going to go through tonight as best we can, okay? Yes, ma'am.
My name is Deborah Ecker. I live at 550 Rio Mar Drive, and I have a question for the commission. My understanding of what you said earlier this evening was that during the time of the moratorium, that you would be a time to have the planning department review the regulations concerning mining. Would it be possible for you to direct the planning department to expand those considerations to look at all of the types of uses that are permitted under Chapter 11, Section 4? Because there are many others that I think homeowners would not be happy with.
We probably could, but tonight we're really only talking about, and we're still talking, nobody's voted, so but the fact is whether we have a moratorium or not on mining regulations.
Okay.
To broaden that would be something into that it would be not considered tonight. No, ma'am.
Okay. Thank you very much.
Thank you. I think we're going to let the big fellas talk first, if that's all right.
Hello.
Could you state your name and where you live, please, sir?
Hello. My name is Nathan D'Ambrosia. I live at 8166 25th Street. I am against rock mining. I want to stop this because every night I walk my dog on 82nd Avenue. The road is so busy and everyone drives so fast. All those trucks would make it so much worse. In the morning, I have to go to school, and I would not be able to get off my street because of all the trucks. This is crazy. The people that want to do this are not thinking about the environment or the people that live on 82nd Avenue. It is so peaceful in my neighborhood, but if this gets through, we would just hear the trucks all day and the mine. We see lots of wildlife, and it is really quiet. But it will all change if you allow a mine in my house.
Thank you. Yes, ma'am.
Hello, my name is Dale Simchek, 766 South Easy Street, Sebastian. I come before you not as the City of Sebastian Council, but as a single council member. Moratorium equals time. Time. That's what this whole community is asking for, time. I have sat where you are and counted on staff to advise me in terms and language I can understand. Your attorney has advised you that you can issue this moratorium and you can issue it across the board. The reason I wanted to speak to you tonight is that notification was one of the primary areas that concerns me. And the last time I came before you was an issue that there was a gross zoning error in the fact that concrete batching was in light industrial. And it was very close. There was a parcel of land to the east of my city and to the north of my city. We had no control of the application, and we're strictly at your mercy. Old rules on the books needed to be revised and looked at. I think you have a similar situation here. We're asking for time. As far as notification is concerned, I feel that the neighbors of this project within the county are concerned and want proper notification. But may I suggest to you that municipalities that are joined by either boundaries or water, flowing water, I feel deserve the same consideration. I have Mr. Bowling, maybe you can help me out. Please excuse, this is just something that I've used as a tool for speaking casually, but it's not prepared by staff. That's probably about it. A little, and I think that it might be hard to see, but you're going to be looking at the southern area of Sebastian, and this is 510. This is your lateral C right here, lateral C body of water canal from 1927 that goes all the way north, and oddly, north is downstream where I am. It goes up and it curves into the south prong of our river and the headwaters where the spawning and a lot of our nature takes place. Some of your mining applications that we won't mention are in direct proximity of this canal. Tonight we've talked about containment and hydrology, but thank you, Ms. Keyes. You did mention about non-containment, flowing canal water to the prong, to the headwaters, to the river, to the backyards of people in my community. I really need to stress to you at this time, we're working so closely and so hard on interlocal agreements to work with communities all together for safety, for boundaries, for utilities, for water, and that it's time to look at the LDRs and perhaps put in a stipulation that we would at least be included in a review, or at least included as a courtesy. Economic development as an excuse for safety and health and welfare is a bad excuse. 6 months is all they're asking for, is a time for review. And I won't take up any more time, but I want to just ask that a consideration and a respect to other municipalities that may be involved with impact to these projects be respected. Thank you.
Thank you, ma'am. Mike?
Mr. Chairman, members of the committee, I'm Mike Ziegler, reside at 3375 12th Street, Vero Beach. I seriously consider, as you do, the impact, and I would hope that you would take seriously the knowledge and intelligence that you'll gain during the moratorium. Thank you.
Thanks, Mike. Yes, sir.
Good evening. I'm Tim Glover, President of the Friends of St. Sebastian River. I have just a couple of brief comments. Earlier, Mr. Adair, I think, pretty well summarized one of our major concerns, and that is for the hydrology. One of the other ones is the St. Sebastian River itself and potential impacts. And as Mr. Simchek just indicated there, the Lateral C Canal, which is adjacent to a new type of proposed mine in this county, drains directly to the south prong of the St. Sebastian River. So we would be concerned with whatever potential impacts that might create. And I think that's something that we don't necessarily know what that could be. So I'm hoping that you folks could support the moratorium, and so we could learn more information about that. Thank you.
Thank you. Yes, sir.
Good evening, Councilman. My name is Larry Hegel, and I reside at 6360 8th Street in Vero Beach. I was prepared to talk about a little bit about wild turkey, but I think the councilwoman from Sebastian made a great point. Can we put the slide back up about the Lateral C Canal, if you don't mind? And she did state the fact that the water in this county flows from the south to the north. And I have a little insight I wanted to share with the community that never really makes the papers. In 2004, I was the contract holder for Wild Turkey. And I had planned on I was with a group out of Tampa, Zones Development. And we talked about putting 5-acre ranchettes in this area. And of course, everybody knows it's right along 82nd Avenue. We found out some information. The first thing was, the county does not own 82nd Avenue all the way to Wild Turkey. So part of the discussions we had with everyone was the purchase of that right-of-way from Sebastian River Water Control District and paving that road. So another concern when we talked to the Water Control Management District was that this canal right here has a lot of nutrients and pollutants that go into our river that take the oxygen away. And the people that laid out our county, what we did is we dug these canals to drain the wetlands and to make our property habitable where we could do agriculture and vegetables and eventually citrus. Now, these canals right here that are everywhere in this town are not good for our river. And we have very poor, antiquated dikes and gates that control this water. I agree that we should look at this real close, because some of the retention ponds are needed and are requested by St. John's because of the nutrients that are going into our river. That canal flows and drains our lands with all our pollutants, and we need to retain that water. And it does a purpose. The sediments would settle in the bottom of that pond. Plus, there needs to be a bridge that goes from 82nd over to Wild Turkey. One of the things that we had proposed in this development was a bridge with a gate, and we were agreeing to dig an 80-acre pond on this and donate that to the appropriate authorities for this purpose of settling the nutrients and treating that water before it's released and continues down this canal into our river. So I can't, no one can deny the fact that there's increased traffic. We cannot deny the fact that it does disrupt the groundwater. I mean, that's indisputable. But we have to do something about that canal and what it dumps into that river. And if we limit the depth of this pit, that we can limit the disruption of this aquifer. So there is a balance here that there could be some pauses. You know, I am all for letting us take a deep breath, but I think you need to bring in some people from St. John's and let them give you opinion what's flowing in that canal, which is the eastern border of Wild Turkey. So there are some positives that no one ever says in the paper, and that's all we read. So if we don't dig it too deep, it could be positive. What do we do about the trucks? Okay. Their application says that they're going to go 65%.
Their application says nothing right now, sir.
Okay. I understand it's revoked, it's pulled, but I'm just saying that we could get some roads paved that doesn't come out of our pocket, and we could get a retention pond that settles these nutrients, and it could be treated before so we need to think about this. Since we're talking about the moratorium, yes,
I would say that it sounds like to me that you are not necessarily in favor of the moratorium. You would be more prone to be in favor of sand mining for use for pumping back in for settlement. So
that's correct.
There is some positives. Not that we got anti-mining and pro-mining, but I mean, you're not.
We're in this very sensitive balance, and maybe Mr. Davis can. Right here.
I understand. For the moratorium's sake, I mean, this is something that you would feel like that maybe.
Why don't we take a break and look at it and bring in some experts? I'm not opposed to that, because we have an application from our county right here to St. John's to convert some old sand pits on 74th and 4th Street for some retainage and clean up some water. That's if you go to St. John's, and you can pull this application that we are going to convert into try to clean up our canal from our runoffs from these canals, because there's a balance here we all have to look at.
There's some pro in favor of that. Okay. Yes, sir. Over here. Anybody else from over on this part of the room? I know Mr. Latour. Come over here. Yes,
Good evening. My name is Don Simon. I live at 8080 24th Street in Vero in Westside Villas. I appreciate the opportunity to speak before you tonight. I feel that moratoriums should only be reserved for important matters, and I'm certainly in favor of the moratorium. I can't think of anything that would be more important than looking at this issue more carefully. I feel that the Wild Turkey project is totally incongruent with the character of the neighborhood up there. Secondly, because it's this has probably been mentioned before, but I feel it bears repeating, that it's next to the Sexton Ranch that the
We're really not talking about wild turkey now. We're talking about mining, a moratorium on mining in the entire county.
Right. Okay.
Okay.
All right. And then finally, the comments that the young boy brought up resonated with me. I live on 4 houses off 82nd Avenue. This morning, I was out riding my bicycle up on 82nd Avenue. There are no bicycle paths. There are no walking paths. While I was out there, I only had a few minutes, and while I was riding out there, there was four big dump trucks came rolling by, and they're really big trucks, and I don't want to see more of that.
Okay.
Thank you.
Thank you, sir. Yes, ma'am. Yes, ma'am.
My name is Fran Denhart, and I'm a resident of the Ranchland Mobile Home Park, which is located at 2855 82nd Avenue and State Road 60. I had originally hand-delivered a petition from our park signed by our residents who opposed any and all mining in this area, and I'm sure you all got a copy of it. I would just like to say that I would suggest that you do put a moratorium for now concerning, because there seems to be so many different problems. Now, our biggest concern is that we were going to suffer more than anyone else, because we're going to have trucks, and they're coming now up and down 82nd Avenue every day. And to add 400 more to it, well, that'll be another problem to deal with. So it's nothing to do with politics. It's just the health and welfare and the safety of our residents in Ranchland and also our neighbors that surround us. Thank you.
Mr. Latour. Digame.
Good evening. My name is George Latour, 2332 Vero Beach Avenue. And I'd like to make a little statement here. The time we came here to Vero Beach locally in 1959 from Cuba, and the beach was all trees, and then someone built the Village Spires, which was quite a tall building, and the county commission, the city council, they got concerned, and they put a limit on height, and that has protected us for all these years, which that's the reason Vero Beach is what it is, one of the things. Huh? The same, I believe, has to be done with the mining and the related items that through the years have become outdated due to change in conditions. In my view, the only way to accomplish the previous statement that I made is to give to the people the opportunity to have an input in these matters. What years ago made sense, maybe now does not. And I respectfully request that you, the Commission, recommend to the County Commission for an ordinance imposing a moratorium on acceptance of applications for mining, administrative permits approvals, and issuance of mining permits. And last, I would like to see in the audience how many people live in Indian River County to raise their hand.
Everybody.
So I think everybody has expressed themselves, and thank you very much for your time.
Is there anybody else who'd like to be heard? Yes, sir. Anybody else in the audience? Okay. Would you like to go now or later, sir?
That's fine. I'm Tom Cowan, President of Fly-In Ranches Homeowners Association. That's we're on near 86, just down the road from Mr. Fisher's proposed pit. We would strongly urge you to make a broad scope moratorium that would include all mines, especially the deep pitted excavation type mines that are on the books. Because certainly, I don't think when these were approved, like the Fisher application at the April meeting, that you even considered the water issues that were involved and were brought up tonight. Most of that was passed off to St. John's to check. And no one here said anything about the water issues. And this is a major, major part of the strip mining, the deep excavation type pits, that once our aquifer is penetrated or mixed with pollutants, that is something that isn't going to change. And we're going to spend millions and millions of dollars going back and trying to reclaim our water from this type of operation. And I don't think there's nowhere that I can see that anybody that bought property in agriculture expect to have a strip mine next door to them. And there's, I don't know how the county can even consider mining in the same breath as agriculture with citrus and ranching, cattle. It's a completely different type operation. So we would strongly urge you to make at least a 6-month moratorium on any new mining permits being issued, whether they're in the application process or not. Thank you.
Thank you, Tom. Okay. I think, unless there's a burning desire, this lady and then this gentleman will be the tail end, if that's, I hope. Okay? Mr. Days, you want to speak? Okay. Yes, ma'am. You're first. Go ahead.
Yes, thank you.
You won the lottery.
Oh, well, wish. My name is Virginia Kerner. I am a resident of Sebastian. I am here as an individual. I sit on the Natural Resources Board for the town of Sebastian. I have grave concern regarding the water. If this mine is allowed to go through, the contamination that will flow down into the Sebastian River and out to the Indian River Lagoon. Right now, I am working with a member of the Department of Environmental Protection to enhance and improve the water quality at this Indian River Lagoon on Sebastian Waterway. Right now, I was told that we have one of the best aquatic preserves along the Indian River Lagoon. And should this mining go through without in-depth study and protecting the public and the water supply, I'm afraid that one of our best resources and one of our probably one of the incomes that Sebastian enjoys through visitors and fishermen, our commercial fishermen will suffer. If you came down to this place called Squid Lips and stand on the docks during the hatching season, you could scoop fry up in your hand. There are millions and millions of fry. When we start playing with our water supply, the enjoyment for all and the income for many will go by the wayside. I also have just something that concerns me as a citizen. When we start talking about the water being depleted in our aquifers due to mining, I have to think of all the homeowners. The county has placed water restrictions on us as far as sprinkling, and we can only water our property so many hours a day, or so many days a week, and we're going under tighter restrictions, from what I understand. This is minimum. This is minimal. Our use is minimal compared to what would affect the aquifer and what we would lose. We have to keep in mind what happened in Georgia. If we are ever in a severe drought, we're going to have to tap into that aquifer, and we want it as pure as possible. Thank you.
Thank you, ma'am. Councilman?
Thank you, sir. Thank you, Mr. Commissioner. I'd like to just add my thoughts to this. My name is Ken Day, Vero Beach City. That's where I live. And watching all the folk come up tonight, I consider our county and where we live a very unique place. I consider us very blessed here. We have a very blessed environment. And I think the one person that said it all tonight was the young man that came up and spoke. He spoke about it all. He spoke
can't
about
vote, you know.
I know he can't. But if you listen, all the other folks that came up, they had a lot of technical data. A lot of the folks that came up and spoke before you all, they do that because they care. They're not paid for it. And you heard from your citizens, and they're asking your help. We need you folks up there to stand unified and send a message to the county commission. Look, we need to take a look at this. And back to the young man, he said it all. He spoke about people. He spoke about the environment and what he cares about, and he's very young. We need to be mindful of the environment. We need to be mindful of the people here. We need to be mindful, if you looked out in the audience tonight, there's a lot of young people. We need to take care of it. There's folks way before us that really cared about this community. They really, truly cared. I've met a lot of those folks over just a short time that I've been in office, and even before I've been in office. They care. Please help us. Please stand together. Please send a message to the county commission. Let's just take a little breather. 6 months is not that long. There's a lot of tools in the toolbox. We have a lot of specialists that can take a look at this. They can give the information to staff and come back. Let's just back up a little bit and take care of what we have. Remember, this is a blessed community, and let's keep it that way. Thanks for your time.
Thank you. Anybody? Yes, sir.
Mr. Chair, Commissioners, my name is Jonathan Ferguson. I'm an attorney with the law firm of Rudin McCoskey. I am hired by Wild Turkey, but obviously I'm not here to talk about Wild Turkey tonight. And I realize I made a mistake in wearing my dark suit. I am not from Washington, so hopefully that will balance out.
If you were a little younger, it might help, maybe.
Yeah, well, I apologize for that. Not much I can do. We all wish that sometimes. I'd like to make 4 issues, and actually I'm not speaking for or against the moratorium, per se, but what I'd like to do is point out a couple items that I think that...
I know that's not a cell phone, I hear.
My time's up, I take it?
Yeah.
That you have a very important job in making a recommendation to the Board of County Commissioners. And I think everybody in the audience understands the importance of your recommendation, which is why they're here tonight. And I think that all the points that were made and the opinions expressed by the audience tonight were very important. However, what you do not have in front of you, and why it is critical that you have it in front of you, is that a moratorium is a very serious matter. Granted, the issues and the opinions expressed and the issues that were raised are very important. However, what you don't have in front of you tonight is an opinion from your professional staff whether or not the existing regulations are adequate to address the concerns that were raised tonight. A reminder, and it was brought up by Mr. Paladin, that your Chapter 934 mining regulations were amended as recently as 2 months ago in October. And they were amended, as I understand it, because of concerns from a project back in March, April. And so your professional staff had all summer to work on amendments to those regulations to deal with issues raised by mining applications. To then say, a week after those amendments were adopted by the County Commission, that there is in essence an inadequate regulatory scheme dealing with mining permits in place seems a little bit odd. So I would suggest that at a minimum, you should request a professional opinion from the professional staff that is charged with reviewing mining applications to give you an opinion whether, and they've heard all the opinions and the issues raised, whether those issues are adequately addressed by your existing regulations. If they are, then there is no need for a moratorium. You may want to relook at some of those and tweak some of those, but that does not necessitate a moratorium. Second point, you have a somewhat cursory opinion from the county attorney's office that moratorium are legal. I would agree with that opinion in the broad sense. You have heard other legal opinions tonight that absolutely moratorium would apply to pending applications. I would respectfully disagree with that opinion. They are dealt with on a case-by-case basis. I think that you are due and have a responsibility to have the information as to what all of the legal ramifications of a potential moratorium are, because it affects the county. It affects the county's pocketbook. It affects the county's health, safety, welfare. What you do not have is a detailed legal opinion as to all of the ramifications of imposing a moratorium at this time, its effect on pending applications, and it may have a different effect on different applications depending on where they are in the system, its effect on future activities, its effect on property rights of people, and maybe more importantly, and more importantly for the audience that's here, whether or not a moratorium is going to have the effect that I hear everybody in this audience wants to see, which is a prohibition on mines. And I think you are owed and have a duty to consider whether or not that is legally feasible before you make such a serious recommendation to the County Commission to impose a moratorium. Because if in fact a moratorium won't have the desired effect that you've heard tonight, then I think that weakens the argument for the need for a moratorium. Third point. There was made reference to a law that was passed this past legislative session, went into effect in July. That law was a direct outcome of a study that was paid for by the Florida Department of Transportation that had critical concerns about the adequate supply of aggregate material. And because aggregate material is a mouthful, I'm going to shorten that to rock. FDOT is the largest user of rock in the state of Florida. They had a concern, in part based on the federal judge's action in the Lake Belt region of Miami-Dade County, which has curtailed some of the supply areas for rock in this state, that they wanted to see a comprehensive review of the rock supply in the state of Florida and what were the impediments to the continued free flow of that supply. Because there was a finding that the sufficient supply of rock in the state of Florida is critical to the economic well-being of the state of Florida. FDOT's study found that if you shut down, theoretically, the rock supply from the Lake Belt region of Miami-Dade County, you would have a negative impact of $22.8 billion on the economy of the state of Florida. Obviously, that is not going to happen, but that was a worst-case scenario. The study found, for example, that Indian River County in 2004 used 1.2 tons of rock. You need a steady supply of rock to maintain a viable economic balance in this county and every county in the state of Florida. Because of that study, the legislature took action. And they passed an amendment to Chapter 337, and Mr. Paladin quoted that to you. It's 337.0261. But I think it's important that I read the preamble to that legislation that's been adopted. It reads, quote, legislative intent. The legislature finds that there is a strategic and critical need for an available supply of construction aggregate materials within the state, and that a disruption of the supply would cause a significant detriment to the state's construction industry, transportation system, and overall health, safety, and welfare. And because of that finding, they adopted the provision that Mr. Paladin read that says before local governments can take action, they need to request and receive an opinion from the Florida Department of Transportation as to the effect of that action on the local, regional, and state supply of rock. I would suggest that your staff has not had the opportunity to make that request of FDOT, so you do not have the benefit of FDOT's opinion as to the effect of the moratorium on the Indian River County rock supply, on the regional rock supply, and whether it has any effect at all on the state rock supply. Based on those points, again, I'm not arguing for or against a moratorium. I knew that would.
Come on, people.
I said that just to lighten up the crowd. What I'm arguing is that you do not have sufficient professional opinion from the staff to make an informed recommendation to the county commission. And I would suggest that it would be your responsibility to continue this for a month so staff would have the opportunity to give you that information. After you receive that information, if you still find there is such a serious consequence of not having a moratorium, then certainly make a recommendation to the County Commission that there should be a moratorium. But in the meantime, I would strongly argue that you do not have the adequate information to make an informed recommendation. And your duty as the P&Z, as you all well know, is to make a recommendation based on the best information that's available to you, and you do not have that. Through no fault of staff, this has been sort of rushed through, and they've not had the opportunity to get you that information. So, again, I would suggest and recommend that you continue this, and if you do, I will be back up in front of you at that point, probably arguing against the moratorium. Thank you.
Okay. Anyone else? Last last strike. Okay.
I guess I'm the last person. My name is Martha Redner, and I live at 9 River Oak Drive in Sebastian, Florida, in San Sebastian Springs Development, which is right next to the Sebastian River. And between myself and my parents, we own 100 acres right across the street from Treasure Hammock with cattle and horses. I am for the moratorium. I would like to see more in-depth study, because this is a rock mine, which is very different than a sand mine, as you've heard. And I've been in Indian River County for 40 years, and I hope to live here for 40 more. I have 2 young daughters, 10 and 12, and I hope to see them live in this county for a long time. I'm nervous. Indian River County is a very special place, and we all know that. That's why we're here. It's very different than any other county in the state. So I think we really need to look at this and consider that the citizens of this county are more important than rock. Thank you, and have a good evening.
Thank you. Any new information to come forward? Mr. Higgs, I'm sorry, sir. Have a seat. We've had our shot. We've got one more behind you, I'm afraid. Yes, sir.
Good evening. I had no intention of speaking tonight. In fact, I really wanted to stay home because my daughter called me and said she was just getting engaged today.
Congratulations.
So,
congratulations.
Thank you.
I think.
Now I got to pay for it. But all those things aside, it's my personal belief that the future of Florida does not depend upon rock. It depends upon water.
Could we get your name, sir?
My name is Jim Gallagher. I live at 766 Holden Avenue in Sebastian. In fact, the Press Journal, not earlier this week, had written an article about the importance of water in the future of Florida, its quality, and its availability. It seems to me that if there is new information, as we just seemed to hear earlier tonight, about the problem, if I got this right, of evapotranspiration, that's quite a word, and its possible effects, as well as the possibility of damage to the Sebastian River, which in turn flows into the Indian River aquifers, excuse me, not the aquifer, it's the Indian River Lagoon, for which our senators, after fighting for years, finally got millions of dollars released from the federal government to clean that up. It would be absurd for us to not consider posing any study that would make sure that we would not further damage the Sebastian River and, in consequence, the Indian River Lagoon, and whatever federal requirements that would be afterwards. In addition to that, sometimes moratoriums are necessary just to avoid major problems in the future. The state of Pennsylvania and the federal government, assuming that Americans generally, by and large, supported our troops and had a great deal of respect for their graves, never anticipated developers wanting to put in a Walmart and McDonald's over the graves of Civil War veterans at Gettysburg, but they did. Some people are concerned about money. and rightfully so when they have property. But people who are representing the common weal in English history, which is the commonwealth in our studies, are supposed to represent more than just money interests. They're supposed to represent the future of everyone. Every religion in the world, as far as I know, says that people have to be stewards of their environment and every part of that environment. I ask you to please do that. I ask you to do that so someday when my daughter has children, I can show them a beautiful spot in Florida where I live. Thank you.
Thank you, sir. Is that everybody who has spoken their piece? Public hearings are now closed. Commissioners, we've got a decision to make. You may want to ask staff how they feel about the current law versus the potential for moratorium, because they haven't spoken to that yet. But if not, if not, we'll entertain discussion and then a motion.
Well, being the mild, meek, withdrawn person that I am, I'll make a recommendation that we recommend the BCC, Board of County Commissioners, impose a 6-month moratorium on mining sand and limestone in A1, A2, and A3. They will be able to decide on the appropriate public hearings, study teams, et cetera, as appropriate.
Do we need to include exemptions or not?
You don't need to. You can discuss them if you think it's a good policy to have them.
Were you include? At what point were you drawing the line, Mr.
I'm not drawing any line. I want a complete bloody moratorium.
Is that to, Craig, is that to include applications that have been made?
Yes.
Okay.
I second the motion.
Okay, motion is made and seconded. Just for clarification, there are parts in here that we probably should, if you're going to talk about that, we need to at least I need to understand. Are we talking about renewals in September if it goes past that point? Or
no, I would lay in the existing programs that are out there.
I'm not sure you have to deal with it because 6 months is still prior to
that's prior to the moratorium in
September.
Hopefully, yeah.
Okay. But there may be.
If it goes on beyond that, the Board of County Commissioners will have to deal with it with the moratorium in place.
What about the?
That's called passing the buck. For those of you that haven't been in politics.
What about administrative lighter uses, Bob? You had asked about some of the. Enlighten us on what you're talking about. You got. Stan, it was built whether buildings can be added to existing mines or.
Right. I think the question is with those existing mining operations that are already approved and permitted out there. We do from time to time have staff level approvals. There might change, a minor aspect of the project itself. I mean, it could be a number of things. It wouldn't be the total amount mined. Or anything like that, but there could be some changes on site. And I think the question would be, if there's an approved ongoing mining operation, can they make those staff level type
I
of
think
changes?
those belong where they are right now at staff level. I'm talking about new mining or anything that's in the pipeline.
Will, I have a question. With the motion that's now on the table, I'm assuming then that mines that are in current operation and have been approved from September or October would then be affected the next September or October if there were regulations or changes that would affect new mines, then they would also affect the applications for mines that are in operation.
I think that's correct.
That was my intent.
Mr. Chairman.
Yeah, Ann.
In what ways would this affect the building of the school at 66th Avenue?
What's the
Could
timeline for that school?
Break ground probably early in January, February. Would it affect digging retention ponds?
No, I think the mining moratorium, and correct me if I'm wrong, Will, would involve any type of mining operation that requires an administrative permit and that's regulated through our Chapter 934. We have development projects routinely where part of their development approval is changing grades and digging ponds and so forth. It's part of that development. It's not a mining operation per se.
Just keep it shallow, Ann.
Is this,
I'm not an engineer. I don't know what they need to do.
Craig, in this entirety that you're talking about, are we talking, the current rule as well as written deals with some specifics, traffic, et cetera. Are you expanding upon what he has written?
No, the language about traffic and notice is just in the whereas clauses, which lay out some of the reasons that the moratorium was suggested in the first place. If the moratorium is in place, any and all issues should be on the table.
Okay.
It's an open field.
It's open regardless then?
Yes.
Yeah.
I have a question, Mr. Fletcher, on your motion. I think Mr. Collins discussed some of the mines that are west of I-95 or for the Route 60 project. Would you consider restricting this just to the mines east of I-95?
Not really. I think we need to look at all of it. This is a burning issue. I'll give you why I'm so hardcore on this now. I guess everybody's already had their dance. I'll do my dance. As long as I've been here, George and the Knights and I have all been here for a couple 100 years. Well, not quite that much, but I've seen, when I go hunting and everything or go flying, I have seen quarries come in and do coquina rock mining, especially the coquina rock where the aquifer is. And you can literally see downstream of them where everything dies because they interfered with the aquifer. And I think we need to take a serious look, step back, and stop this. We don't have any more water. I want to stop all of it and have a good technical study done to see what we're doing here.
By going into a moratorium, is it fair to assume then, if we recommend this to the commission, that we will in fact have workshops, the technical back up, the scientific study that people have alluded to, or Craig wants, or does he need to include the request?
No, that's the whole point of the moratorium, to
have
the time to do those things.
Okay.
That's what I said when I said they could do with appropriate hearing study teams as appropriate, was part of my motion.
Okay.
Not emotion, but motion.
Any other comments or questions?
I just think that the moratorium will allow, being an ex-educator, it will allow education to occur for the entire community and to understand this. There's a lot of misinformation out there. There's a lot more information that we have about this process than, of course, we've discussed tonight. But I think that's one of the things that can come out of this, is that we as a community and as a county will really understand the issue when the commission comes back to act.
And we'll be a big part of that, I'm sure.
Anyone else?
Yes, what about the two mines that are in the city of Sebastian? I don't know the legalities of how this can apply to something outside the county.
The ordinance, an ordinance adopted by a county applies countywide unless the city has an ordinance speaking to the same issue. So I'm sure that there must be some mining regulations within the city of Sebastian, or at least I assume that. And so I don't believe this would have application to their mines. They've got their own regulatory regime. And if they have an inconsistent law, then their law prevails over our countywide ordinance. Only if they had no mining regulations whatsoever would this apply in Sebastian or any other city.
Mr. Chairman, just to explain something that you may want to address directly. Chapter 934, what we've been speaking about, I think, this evening are the type of operations that can operate for up to 10 years, that get an administrative permit and then subsequently get annual mining permits. We also have provisions in Chapter 934 for what's called incidental to construction mining that occurs. And we do have allowances for for very short timeframes, for instance, predominantly a 2-month window of, if you're developing a site and you dig a pond and you use most of the fill on the site, but you have excess fill, we do have an allowance. It's called incidental to construction, where you can truck the fill off-site for up to a 2-month period. And we do have those from time to time in the county. It's called an incidental to construction permit, and it is in Chapter 934. There's one other provision that goes beyond that for very large projects, 350 acres or larger. They can truck off site up to, I think the total extended period of time is 18 months. Those are much more rare because we don't have projects that big, generally speaking. But those are called incidental to construction permits. They are in Chapter 934, and you may want to make a recommendation whether you intend for the moratorium to affect those or not. But again, those are pretty common, especially the smaller scale ones. When you're exporting more than 5,000 cubic yards of fill, it happens on a number of projects. It's not an ongoing mining operation, but it does allow trucking fill off-site.
Do we have any of those that you know of that are ongoing currently? The larger ones, we don't have any that I know of.
Well, the only large-scale one, we've had 2 large-scale ones. One was Bent Pine, when they were enlarging a lake at Bent Pine, and that's over and done with. Again, they had the maximum 18-month window. Waterway Village is another, and they've gotten to the end of their time frame for trucking off-site. But it happens pretty frequently for the ones that allow the 2-month window. I mean, it could happen dozens of times a year.
But in the pipeline, do you see anything like that coming?
Not the larger one, I don't.
What I'm alluding to is, in the last 6 months that we've been here, we've had one development come in for 39 homes, I think. So within the 6 months period, I don't see anything coming down the road in 6 months that's going to be affected.
But what you could get is the incidental to construction that has the 2-month time frame. Commercial projects could have that. We had the Century Town Center shopping center project on State Road 60. They had a 2-month time frame because they had more fill than they could use on site. They had to get rid of it. They had to take it off site.
Well, I'm open to suggestion for.
So I just want that incidental to construction is a little different, and it's a very shorter time frame, and you may want to make that clear.
Is there a clear definition on the size in your regard with incidental on big, small, large projects?
Right.
So if he needs
on the incidental to construction that we mostly deal with, the real limiting factor is it's Monday through Friday, and not on the weekends that they can truck off site, and it's a 2-month time frame. So they've got a narrow window of how long they can truck it off site, and that limits how much they actually take off site.
I actually don't see having a problem. I personally don't have a problem with that continuing.
I'd like to see it amended, the motion, to include or exempt incidental mining or construction.
I'll go along with that.
Second or go along with them?
Yes.
Okay.
Well, we have a couple other
Mr. Chairman, I
exclusions
feel
we
better
talked
about that, too, because that's the one thing that worried me about the school having to dig a retention pond or something. I just didn't want a problem with it. I imagine, because the property is so large, that we can keep all the fill on the site, but just in case.
The school is exempt from a lot of our codes already. They don't have to.
But we want to be environmentally sensitive on this. This middle school is going to be an environmental.
You're not going to be impacted by this.
It will not be affected by it at all.
Your ex-builder down here.
Okay. Thank you.
Donna?
So what I see is we have 3 exclusions to this: operating permit renewals, incidental to construction permits, and administrative approvals of minor site plan changes.
Correct.
Did you exclude the excluded renewals?
Yeah.
Those renewals won't happen until September, and the moratorium should be over by then anyway.
I said I didn't know that they needed.
Yeah.
Staff I am a little concerned about the mining associated with the completion of State Road 60 west of 20 Mile Bend, et cetera. Are those mines that are permitted there, are those specifically for the allowance for the fill associated with the State Road 60 and would need another application if they were to continue with any other type of endeavor other than State Road 60's development?
Right. The three that I mentioned are still active, and they are limited to using the fill with the project. I don't know if those mining operations satisfy the needs of the project or not. We've not been approached recently for any additional fill, but I don't know whether or not any additional operations would be needed for the State Road 60 project.
I bet you they'll tell us as soon as they need it. We'll find out when we go through this. But they are exclusive to the use of Route 60.
I would like, myself, I won't vote against this, I'm going to vote for it, but I would like to see those excluded also, if they are exclusively for the completion of State Road 60 in Indian River County.
I can buy into that because that's a safety issue. We need Road 60 finished, and we absolutely must have the fill for that. Yeah. See, everything's negotiable.
Okay. Anything else? Okay. Everybody understand the motion?
Could you repeat the motion one more time?
Okay. Recommend the Board of County Commissioners impose a 6-month moratorium on mining sand and limestone in A1, A2, and A3. The exemptions would be the renewals, which will be done by staff. The mining for Route 60 fill, that's 2. There were 2 others.
Administrative approvals of
administrative
minor site
approval.
plan changes and incidental to construction
And
permits.
incidental to construction be exempt. So it'd be 4 exemptions.
Right. Okay. All those in favor say aye.
Aye.
Aye. Opposed? Like sign? Appears to be unanimous. Is any... We have 2 other items on the agenda tonight, so if any of you all are leaving, please do so quietly. We'll take a 5-minute break.
Oh, good.
The agenda is a public hearing to a much thinned public, I see. A consideration of proposed LDR amendments for Chapter 973 public nuisances.
Mr. Chairman, I'll present some background information on this LDR amendment, and George Glenn, our Assistant County Attorney, will as well. Planning and Attorney's Office worked together on this particular amendment, so I'd like to go now to a PowerPoint presentation. The changes that are proposed and you all are to consider, make a recommendation on tonight, are to Chapter 973, our public nuisance ordinance. There are two cases that brought the Board of County Commissioners to direct staff to initiate these changes. So these are county-initiated changes, and they are county-wide, but there are two cases that brought these to the forefront. One is an egregious code violation of Bureau Lake Estates. I'll show you a picture of it in a moment. And that particular case has gone all the way through normal code enforcement action, including fines, and there's still no action for compliance. And there's a regulation change that can allow action to take place. The second involves Vista Gardens and Vista Royale, weed height problems. That is an unplatted multifamily project, and our current weed height regulations do not apply to unplatted lands. This first is just one picture, and this property doesn't look any better from the other side, but this is one picture of it, the Vero Lake Estates example, and there are multiple code violations and issues here, but weed height is one of them. It's basically an abandoned, partially constructed home. Again, it's gone all the way through the conventional code enforcement process. Fines have been imposed, but again, there's no cleanup. So what is needed here is abatement, if the county so desires, and that's the second part of this proposed LDR amendment. This is just a picture, one of many pictures we've had on the golf course that really goes through Vista Gardens and Vista Royale, surrounded by residential development on many sides. And it's an active golf course, and there are some weed height concerns on that. The process for this regulation change has been through a public workshop, and the PSAC is before you all tonight, and it's scheduled for adoption hearing before the Board of County Commissioners on January 8th. Again, the two sections, the first section deals, that I'll go into in some detail, weed maintenance, especially for multifamily developments, is the first part. Second part is abating nuisances that are not corrected through normal code enforcement process. Regarding weed maintenance, when we say weeds, weeds are defined in the LDRs. There's no proposed change to that definition, and it's intended to apply to what we traditionally call grass or weeds that are in an unkempt area. It does not apply to natural vegetation, especially vegetation on unwooded lots. The ordinance basically, and this is true of many regulations in many different localities, the excessive weeds are deemed to constitute a nuisance. And right now, our current criteria are untended weeds in excess of 18 inches in height or a violation if it's located on a platted lot or tract in a subdivision where 50% of the lots are developed. And this would, again, be a lot that's not a wooded lot, but a lot that's been cleared once, and it's in a platted subdivision where 50% of the lots are developed. We have exemptions in the code now, and it's pretty common in localities. Agricultural land is exempt. Conservation land is exempt, and uncleared lots left natural are also exempt. The criteria that we've had have worked for many years, and it was designed to address cleared single-family lots, and that's really the reason for the ordinance being, kind of narrowly defined right now. The recent problem, again, was in Vista Gardens and Vista Royale, and they're not covered under the current regulations because they're not platted. And the proposed change would apply the same weed maintenance regulations to multifamily developments as those that are applied to platted single-family subdivisions. We surveyed other local governments. None of them had regulations that were specific to golf course maintenance. Again, we're talking about a county-wide weed nuisance or hazard. It's not designed, and this regulation is not designed to have any kind of manicured look. Vero Beach has a 12-inch maximum weed height, Sebastian 10. Brevard has no height specified. They have to make a finding on it being a harbor for pests and degrading the neighborhood appearance, and it has to be within 100 feet of improved property or roads. Most regulations deal with a specific height, but there are some other counties, and I won't actually go through and read all of these because you guys have probably heard enough tonight. But 18 inches is what Martin County has. Palm Beach has 18 inches, 7 inches on developed lots. Sarasota County, 12 inches, Lee, 16, Collier, 18, and any river county is 18. And there are many other examples. We generally found that cities had lower heights than counties. Counties tended to be 12 or 18, pretty much, in total. The information we got from our local horticulture agent is that grasses that are common to this area have terminal growing heights that are less than or up to 12 inches, meaning that, I think anything above 12 inches, there is a basis for calling that, excessive. The proposal is to change the height standard from 18 to 12 inches, and that would be in the way it applies now in subdivisions 50% developed with units, and with the language proposed, apply also in multifamily developments, 50% developed with units. Some of the concerns that we had in considerations was that we wanted the standard to be easy to enforce, and we really feel a quantitative standard, a height standard, percent built out, those are quantifiable. There's not a real involved finding to see if there's a violation or not. We want to make sure it was a high enough standard that it clearly constitute a hazard. And we felt that we wanted to address a hazard. If it was high enough standard, like 12 inches or 18 inches, it would be something to address on the entire site. We're also concerned about the long growing season and the practicality of maintaining whatever standard we come up with, which is why 12 or 18 was really all that staff considered. If you set the standard too low, not only is it not necessarily a nuisance countywide, but it's also difficult to maintain. So again, the proposed change is to go from 18 inches to 12 inches, what constitutes a violation, and apply to multifamily what it is in single family. I'd like to just go through now the other part of the LDR changes, and that's...
Can I ask you some questions 2 seconds before you go to the second part?
I will give you more than 2 seconds if you want, sir.
Thank you.
You're welcome.
You said 50% of the units built, not
Correct.
Necessarily occupied.
That's correct.
So in any development, once they hit 50% of the build out, that's the trigger.
That's correct.
And this is adjacent property as well as property?
You're correct. In other words,
I was kind of wondering how we were tying it to the golf course since it's owned by a separate entity, and you're saying because it's multifamily and it's property adjacent to multifamily.
Right.
Legally, they have to.
It's within or the wording is within or internal to a multifamily development, and in this case, I mean, going forward, all of our new projects, this golf courses are accessory to residential projects, and it's part of the same site plan. That's the way we would define it. And you're correct. It's not unusual for perhaps a golf course tract to be under separate ownership and management and so forth in operation. But if it's part of, next to a multifamily development, from a site plan standpoint, it would be covered.
Okay. Thank you. Abatement.
Right. Changes to the abatement provisions, and Roland DuBois is, I would consider, our expert on code enforcement. So if you have some questions on that particular process, I just want you to know he's here and ready and able to answer some questions. But the code enforcement process that we have, compliance is the goal, and we have a process that starts with observation of a violation or receiving a complaint, inspection. Property owner is contacted and given a time frame to comply. And at this stage, this is kind of, before there's formal code enforcement action, a lot of violations occurred. If it's not at that stage, we keep going all the way through these different steps. Formal notice of violation with a requested compliance date. Then the next step, again, if we don't get compliance, formal notice to appear before the code enforcement board. The next step is it actually gets to the board hearing. The board hears it, they make a finding, and put in a formal compliance date. There's a compliance hearing, a finding, a fine can be set as the next step, and then a lien filed. And essentially all the way through this process, at any step, a property owner could come into compliance, and then you wouldn't go to the next step after that. The proposed abatement process, George Glenn is going to get into. I'm going to bring up his PowerPoint. But just, basically what he's looking at is an abatement process that if we get to the point of liens filed and there's still no action, that there is the ability of the county to take action on the property. And just while George is coming up here, the PSAC voted to recommend adoption of the proposed ordinance for both parts, the weed maintenance and the abatement part that George is about to get into.
The city.
Thank
you. Turn your mic on.
If I turn my mic on, I can't. If it's not appropriate now, Stan, stop me and I'll ask later on. But in noticing the process and the steps that are gone through, why would it not be allowed that when someone inside the urban service area, let's say you get a change from ag to a subdivision, and the developer comes in and gets at the point where they get the permit for clearing the site, why not have a bond that would be in force until the property is developed and there are homes, et cetera, on it, so that in that interim period, if the developer goes out of business and then is not going to have a 600-acre area mowed, mainly to keep fires from sweeping through, that then that bond would be available to utilize. You wouldn't have to use county personnel. You just contract it out and have the mowing done.
Well, I think that, there are a couple of issues here. If the concern is that you have land inside the urban service area that's not cared for, presumably that could apply to abandoned groves. It could apply to abandoned projects or projects that aren't going, and you're talking about projects that are cleared, and then there's some sort of ground cover that grows back, and then you've got a particular height of that. And I think the question is, how often does that happen? Do you want to require, a maintenance bond or some kind of performance bond for all projects? School board project, you want to do it for a commercial project, a residential project. The issue's the same. The issue's the same in that if you have ground that's cleared and it's not being farmed and it's not somebody's lawn and it's not a natural area, do you want to guarantee what? It mowed?
Yeah,
Is that basically?
That's going to be kept in a safe condition, and I think the staff could determine the timing of it. Before fire season and then during the summer or something like that. I don't care about that, but I think those conditions could be carried through, and that the person applying for the permit would understand the conditions and the reason for the bond, and then if they don't want to do it, the bond is there to get it done.
Mr. Smith, I think one of the problems with that would be how much is the bond? We don't know going in whether they're going to abandon it for 2 years, 6 years, how much mowing we're going to have to do over those alternate periods of time. And I think the process that George is going to get into lets us deal with those cases where there is a problem and recover the costs.
Okay.
In City of Vero Beach, we've actually filed a lien and then actually taken the property. Once the lien was the value of the property, we've actually taken the property, gone to court.
Okay,
Mr. Glenn, good evening.
Thank you. It's a different view from down here. I have a PowerPoint presentation that I'd like to run through.
Stan.
Oh. Thank you. The section I'm going to talk about is the abatement of the nuisance. As Stan has said, that really this came about because of some really egregious violations in the Vero Lake Estates areas. These are violations that have gone through the Code Enforcement Board process, and they have significant fines running against the property. And yet, while historically this has been enough to convince most homeowners or lot owners to keep in compliance with the code, apparently it's getting to the point where people are just willing to sort of walk away from the property and just accept the fact that it's going to lose its value, it's going to lose its equity. The problem, one of the concerns that came up is, well, why can't the county take action? Why is it that we're limited to simply taking the Code Enforcement Board filing and their lien set against the property. And so to look at the existing 973 ordinance, it gives you two options. The first option is to serve the violator with a notice to appear before the Code Enforcement Board. And as Stan has already gone over, the Code Enforcement Board will do their thing. They'll hold their hearings, evidentiary hearings, compliance hearings, and they'll set the fine if the proposed violator does not come into compliance. And again, the fines typically range about $100 a day, and I think can go up to $250 a day. And historically, this has worked very well. The thought of losing $100 a day of equity in your property has worked very well to bring people into compliance. The second option, which is very seldom used, if not used at all, is actually for the code inspector to notify the purported violator that the property is not in compliance and that they have 30 days to abate the nuisance, and the failure to abate the nuisance will result in the case being sent to the Board of County Commissioners. And the Board of County Commissioners may then abate the nuisance. This is the second option. There is actually an option in our code that allows the Board of County Commissioners to abate the nuisance as it exists. The problem is that there's reading of 973. The language states that selection of a remedy under this section shall preclude the later application of any other remedy under this section.
Ooh.
And so the problem is the Code Enforcement Board is the right way to go through the process. If we were to send every violation to either the Board of County Commissioners or send to the court system, we would just absolutely bog down the system. So that we recognize the Code Enforcement Board is the preferred method. The problem, the code is currently written to say that if we do go forward from the Code Enforcement Board, we are precluded from abating the nuisance. And so it's an either or.
Yeah, that's...
And so to remedy the problem, we have proposed 973 ordinance changes that will, in essence, have only one option. If a county code inspector finds that there's a violation on property, the inspector shall notify the purported violator to show in front of the Code Enforcement Board, and the Code Enforcement Board will go through their processes again: evidentiary hearing, compliance hearing, setting a fine if the violator does not come into compliance. So there will be no option of immediately sending the violator to Code Enforcement, to the Board of County Commissioners, strictly to Code Enforcement Board. The Code Enforcement Board will go through the normal procedures, but they'll do one additional thing under the take one additional step possibly under the proposed changes. If the Code Enforcement Board determines that the violation presents a serious threat to the public health, safety, and welfare, or the violation is irreparable or irreversible in nature, then the Code Enforcement Board shall notify the Board of County Commission. It shall notify staff to notify the county commissioners, who may, at their discretion, direct the county administrator or his designee to abate the nuisance. And so the theory is now what we're doing is we're going to the Code Enforcement Board. Every case gets sent to the Code Enforcement Board. They run through their normal procedures. Say they have a 973 violation. What they'll do is they'll say, okay, you've had your evidentiary hearing. We found that there's a violation. We're holding your compliance hearing. You're still not in compliance. They can do one of two things. They can find that you're not in compliance with 973, and that it's a threat to the public health, safety, and welfare, in which case they'll set a fine, and the fine will accrue in the normal procedures. If you don't come into compliance, the fine will continue to run and become a lien on real property. Or if they find that your violation presents a serious threat to public health, safety, welfare, or is irreparable or irreversible in nature, that's sort of the legal standard, the buzz phrase that's going to have to be found in order for it to go to the Board of County Commissioners, who can abate the nuisance. So that's the extra step. They're going to look at it and determine how significant the violation is. If they determine the violation is so significant it needs to be abated by county employees, that the standard process won't work, then the finding will have to be that it's a serious threat to public health.
Now, you're going to charge them for that service? Because that's actually what it is, because that's what we did at City. If we mowed the lawn, we charge them an X number rate.
Absolutely.
That'll go as an extra lien against the property.
And so what would happen is, say this additional standard is found that is a serious threat to health, safety, and welfare. They can actually set the fine, and the fine can actually start running right away. But say 30 days later, county commissioners say you haven't fixed it, I believe strongly to give them 30 days for a chance to appeal. I think it's problematic to rush right away without notice of appeal to find a violation. That could run into problems with due process. And so they have the one fine running, the $100 a day. Goes to county commissioners. County commissioners say, yes, we agree, this needs to be abated. We have the ability to abate it. Therefore, the county administrator is directed to, either through county employees or its agents, to abate the nuisance. That cost shall also be assessed against the landowner. Now, at that point, because theoretically the nuisance is no longer occurring.
I was going to say, you're current now they're current. Does the fine quit?
Yes, the fine stops, because by definition, if we abate the nuisance, then we can no longer charge them for a recurring nuisance.
Can you knock down crack houses under this law?
To knock down...
That's a great possibility, George.
Let me just, if I might say something, Roland Du Bois, Chief of Environmental Planning and Code Enforcement.
You have to smile first, Roland.
Sorry, not going to happen. The public nuisance ordinance covers more than just overgrown weeds. It covers your junk vehicles, your junk trash and debris. So this abatement might be more than just mowing grass. It could be going onto someone's personal property and towing away what they think has value. So depending on what the situation is, it might be more complicated than not. But the way it works is, yes, it would be a fee charged for the cost. I believe there would also be interest accrued until it's paid off. So that's kind of the approach.
What do you mean by serious threat to public health? I mean, in the last case, we were talking about water, and I can understand that. But now we're talking 18 inches down to 12 inches of weeds, right? And that's a serious threat to public health?
No,
safety and welfare?
That's the point of the conversation, is that might not necessarily be a serious threat. That's why we're leaving it to the Code Enforcement Board's expertise and experience to determine whether the violation is a serious
Depends on
threat.
if you're running through it or falling off a horse.
If it's, maybe at 12 inches or 18 inches, whatever this board decides to recommend, whatever that, for grass, whatever the standard is, maybe that's not a serious threat, but maybe it goes to 25 inches or 30 inches, and maybe at that point it is a serious threat. But I agree. I actually think it's positive that the Code Enforcement Board has some type of discretion to use their experience and expertise to determine when exactly a serious threat exists.
I appreciate that. But do you have examples,
Right,
Vero
if I
Lake
might.
Estates, where we would have some feeling? I mean...
Let me give the example, and I didn't answer Mr. Hammer's question about knocking down crack houses, but I think that would be, we have a separate process for unsafe structures and condemnation and removal of those through the building department. But the example in Vero Lake Estates is essentially a half-constructed house that's open. It could be an attractive nuisance for
Kids
crime to
playing
occur within the building. I would think that what would happen would be the minimum necessary to abate that particular hazard. And it might not be knocking down a building that's not an unsafe structure, but it might be boarding it up or making it inaccessible. I do understand what Mr. Baker's point is, that weeds in and of themselves might not be one of the situations that qualify for health safety, an egregious health safety issue, and that's why it would have to be a determination by a sitting board to make that.
I can understand septic tanks and drain fields and things like that.
Well,
But
we
if you're
had
talking about...
George, isn't this taking over, though? I mean, just allowing the county really to be more proactive.
It's
when
very
in the
much about-
past, we were reactive, and we kept fining, and we could never get anything finished.
Well, that was the problem. Now we
Now they
we
can
had
take
no
it over
option of
and-
going forward. I mean, once the Code Enforcement Board had heard it, we were completely precluded from abating any nuisance, no matter how significant, no matter how much of a threat. And so this is sort of, it's two steps. First, the Code Enforcement Board has to find that there's a serious threat to health, safety, and welfare. And the second step is actually that once it goes to goes to the county commissioners, they don't have to abate the nuisance. They may abate the nuisance if the dollars are there, if the capability is there. Looking at the Vista Golf Course, there's a lot of land there. I'm not quite sure the county can afford perhaps to go in that type of situation and continuously mow it, even if the Code Enforcement Board finds that that's a serious threat to health, safety, and welfare. So there's sort of checks and balances at two different levels here. So I feel that's pretty pretty good covering what is really a threat to health, safety, and welfare.
So how are you going to separate out somebody that wants to do xeriscaping, for instance, in their yard, which is a county policy?
Well,
how are you going to decide? Is this board's going to decide that then?
Yep.
No, let me just say, code enforcement is not always black and white. There are some situations. As a matter of fact, that the PSAC meeting, I raised that very point. We're dealing currently with someone who has an overgrown yard, got complaints. We approached them, they say, well, we're trying to have a natural yard, and even though it was planted as lawn grass, we want it to just grow and see what happens with it. And obviously there's issues there between, is it overgrown weeds in violation of our ordinance, or is it kempt weeds, so to speak, or wildflowers? So it's kind of a challenge, and we do try to balance that. But there's a few levels, again, checks and balances. There's a staff level of determining if it's a violation. There's the code board level. In this case, if we get to the level of abatement, you even go to the next review of the county commission. So you'd have 3 levels of review to make that determination.
My understanding of the old law, of the old rule, is we did everything you're talking about. You jumped through all the hoops you're talking about, but because we went to code enforcement, if you went to the county commission, it was precluded. You couldn't do anything. So all you've done is rewritten it. So they actually have a last step, and I don't let them. They get paid. Let them worry about it.
I tell you, somebody has a natural lawn 18 inches high next to my house. I want it cut. I went some way to get it cut.
So I understand this. Now, with this new reg, if there's a field out there that was a grove and it has 5.5, 6 foot of weeds, it's going to be mowed.
No,
That's agriculture.
we're limiting the application of this
No,
nuisance
you're
ordinance to platted subdivisions or site plans. So it's not going to apply in agriculture areas.
No, I'm talking about in a subdivision, something that's going to be a subdivision now. It was a grove, now it's going to be a subdivision, and it's sitting there with 5 feet of weeds.
Only if it's got half the houses built.
50% of the
50%, and then you would mow it, yes. If it's just
Build out
because
is at 50%.
I understand that. I don't understand allowing that kind of a nuisance to exist in fire season, when you've got adjacent subdivisions and homes, and you've got this hazard sitting there waiting for lightning. To me, that's as serious as
grass.
Yeah.
As such, it's a hazard and can be taken care of, then you could take action
But they're
if the code
saying they won't.
enforcement.
Well, because there's a balance you have to strike. I agree with you completely. There are always nuisances and dangers out there, but there comes a point where you have to draw a line that the burden of regulation is just greater than the benefit you're receiving. If that's the theory, then shouldn't we not, every single piece of agriculture, anything that's not developed, if it has high grass, if it's natural area, if we're really truly worried about the benefit of preventing fires, do we need to start requiring mowing of agriculture, of cow pastures, of affidavit exemptions? We're trying to draw a line where we think the benefit of the proposed regulation doesn't outweigh the cost and burden on the people.
Yeah, I don't think my property would meet this new ordinance, actually.
Are you in a...
So I have a conflict.
Go get them.
I have grass on my drain field, which I'm required to have some sort of ground cover on top of my drain field, right? And it was simpler to put grass in and to mow it. It doesn't do very well because the drain field works very well, and if a drain field works really well, your grass on top of it will die.
Right.
So most of it's pretty dead, but my driveway going in is native, natural stuff, and throughout the period of seasons, it has different types of weeds growing up. They're flowering at different times. So I would think that somebody could take me in here and find me, and you could,
What was your address again, Doc? What was that?
I live in.
Everybody's talking about, we are promoting zero landscape, but that's probably the hardest thing to define what you're looking for.
It is.
That's something I think that gets done when the inspector goes out to the property. I think they make a judgment call.
I think Mr. Fletcher would complain at my house.
I probably would.
But will your neighbors?
They don't like to come over because they're worried about all the animals that are around.
The rats and the mice and
Everything that's native to Florida.
Right.
Well, but, I mean, in all candor and seriousness, though, under the current rules, current law, how would he, I mean, what would you do? I mean, what's different?
Right now, if you look at, we go back to the definition of weeds as it applies, one of the key words is unkempt, and it also essentially is, what it applies to is lawn grass that was planted, that you would expect that it's planted to be mowed. We don't go out there and
No, I understand, but I mean, under the, he's still, isn't he just as exposed or just as potentially liable under the current rule? The question is that, but the county then in that case would have no way to solve the problem.
someone would have to turn him in first.
Right. I mean, I'm just
File a
now that,
complaint.
I'm under the current rule. I'm not sure you're hurting yourself. I think maybe there's a way.
I'm 6 inches closer, actually.
You've gone from 18 to 6. Okay.
Right. You know, we recognize, for example, on the case I referenced where we are dealing with someone who's trying to grow a natural yard, is we refer them to the 40 Yards program to get some further reference that we could look at. Again, we're not trying to. We're trying to meet that balance between.
That's why the definition of weeds is pretty bad, actually, that you have, because there's no list. It's somebody decides. It's a plan out of place, really, and that's a difficult decision to make.
All laws / codes are subjective by nature. That's just why they call them codes. About angels, somebody said, but you've got all these codes. Some people are going to have trouble just like that.
Other than Dick's Yard, does anybody else have a problem with this? I mean, I understand what he's talking about, but I think it's a good move because the county needs. This allows the county to fix a problem if they want to, and in the past they've never been able to do that.
I sat on the code enforcement board for Vero Beach for 4 years, and we ran across the same thing many a times, and we changed ours to do the same thing because of the same. People lived up north, they wouldn't mow their lawn, we had to have some way to, and once that $100 fine went on, you'd be surprised how fast you'll mow your lawn.
So what happens when the county doesn't mow 510, 512, or any of its county roads? Are they going to be fined? Are we going to be finding the county?
They mowed
it. I mean, there's probably a couple angry people out there that say they haven't mowed in front of my house.
We could probably cite ourselves, but normally we give 30 days to come into compliance, and if the county was threatened, the county might respond.
Somebody turns them in, they'll respond.
But basically, this does not apply to rights-of-ways. Again, it applies within development projects. We're going from just single-family to multifamily.
So they're excluded.
So we have excluded ourselves.
But it doesn't, yes, and that doesn't seem very fair.
Well, you know, this
No, but it's realistic.
I think it's a step in the right direction. And if we see problems down the road, we can amend it again. Is that correct?
Better off with it than without it, I think.
Yeah.
Did we interrupt your presentation?
This is fine.
Are you done?
Not quite.
No.
Oh.
It sounds like
I was going to look for a motion.
Should I? Well, let me just move a couple more points in my presentation, and then I think we've. All right, so just in case anyone was concerned, where did I come up with this serious health, safety, and welfare? I didn't make it up. It actually came from Florida statutes, and that's found at Section 162.09. So if you're really interested, and that's where it actually came from. And so I just sort of utilized it. I actually feel that this is probably maybe a requirement. I'm not sure other municipalities use the same standard, but when Florida statute speaks to something specifically, usually anything that conflicts with any local ordinances that conflict are preempted. So I felt compelled to go ahead and mirror the language from Florida statutes. All right, so concerns, and we've already gone over most of these, and I think we've addressed this. Does the county enter the mowing business, the debris removal business? How likely is the county going to recoup money spent to abate nuisances? And is opposing a 12-inch height limit rather than maintain the current 18? And it's going to create a greater burden for the county, for the residents. There's something I do want to point out, that I saw a list of grasses that are most common to the county. And the grass that apparently has the greatest potential for growing the highest is the bahia grass. Right. And bahia grass, of my limited understanding, is the most water, less water needed.
Yeah.
And so, there might actually be some policy questions there. Are we, if we do go from 18 to 12 inch, if you're a developer and you're going in and you're thinking, well, I want something that's the least, least amount of maintenance. I don't want to get caught in a situation where my grass is going to grow about 12 inches. And in that case, I don't want to go to the Bahia, even though it's the more water friendly. I'll go to one of the Augustine grasses or something that doesn't get that high, that needs more water, but I'm more likely insured not to get trapped up in the high.
But the sable palm is a grass. That's 18 feet. So, I mean, under your term of grasses, a palm is a grass. And so I think there's a legal problem.
There are a lot of tall grass.
Cut down the queen palms.
Queen palm.
Yeah, cut them all down. That's why there's a board to review these things. That's why there's 4 or 5 stops along the way to introduce a little reality to it. I think this is a good idea.
Do you want to make a vote?
In conclusion, if there needs to be one, to adopt a proposed ordinance that presents all code violations to the Code Enforcement Board, take away the option of going straight to the Board of County Commissioners, require a finding by the Code Enforcement Board that the violation presents a serious threat to health, safety, and welfare, or is irreparable or irreversible in nature, if that nuisance is to be abated, and then empower the Board of County Commissioners with the option, but not the obligation, to abate the nuisance. That's the recommendation.
Okay, we have, any more questions?
I've got one more, George, and I know no one wants to hear it, but I want to ask it.
Okay, I'm open to the public hearing first.
Oh,
and
sure.
then I'll let
Go
you.
ahead.
Public hearing is now open. Public hearing is now closed.
Proceed.
What will be the,
Just in case.
Anybody wants to say?
I
the votes, I don't want to talk.
Yeah.
Don't risk it right now. Trust me.
I'm going to give,
I thought you were just sitting, I'm sorry.
I'm going to give you a specific and ask the question about the specific. On the corner of 43rd Avenue and 25th Street Southwest used to be a grove, a productive grove. And then it was bought, and it was one of those subdivisions that got caught in this turn down. And now it's weeds 5 feet high. And I know that it's supposed to be cut once in a while for whatever reason. What's going to be the difference in the maintenance of that property with this new?
Is there any homes built on the?
No homes.
Empty.
If it's not 50% built, it doesn't.
There would be no applicable regulations pertaining. Again, there's also somewhat of a difference between health, safety, and welfare and just sort of aesthetic purposes. If there's no houses in there, then the argument for why that needs to be upkept starts to diminish.
What if it's right next door to a completely developed subdivision?
And are we talking about platted? Are we talking about a subdivision that's been platted? And we just feel comfortable with saying that 50% of the homes built was the appropriate standard.
But is there any reference to proximity to a completed subdivision? Okay, that's what I want to know.
I guess the only consolation is, Greg, you're no worse off with it than without it.
That's
At
true.
least you're making a right step. You've gained about 6 inches.
In the right direction, yeah.
You
have to cut down bamboo, too.
All right.
I'd like to make a motion that we moved for staff recommendation to recommend to the Board of County Commissioners adopt the proposed amendments.
Second.
Third. All those in, any other discussion? We got a.
First, second.
First and second is Greg. Any other discussion? All those in favor, please say aye.
Aye.
Opposed? Mr. Baker's yard.
I'll oppose.
Fair enough.
And I think I gave my reasons, but, and I think Mr. Smith brought up a good point about the abandoned groves, and that's not covered in here, and I think it should be. With pepper and exotics coming in, there should be some control.
Hopefully, we're working on that.
Yeah.
Okay.
Another day.
We have one more item on for public hearing. It's Point West of Vero Beach Limited. We could table this for a couple of years. Wouldn't be a problem. I don't
think so, yeah.
Wouldn't have any effect on it.
Chuck is here.
Chuck's over there grinding his teeth going.
Request to modify the approved plan development PD conceptual plan for Point West. Okay, who's got it? Brian? Vice.
Thank you, Chairman Hamner. Brian Freeman, Senior Planner. This is a request to modify the conceptual PD plan for Point West. And the process involved with this essentially is through the special exception public hearing process, and involves 2 public hearings. At this public hearing, the Planning and Zoning Commission is to make a recommendation, and at the second public hearing, that will be before the Board of County Commissioners, and they will take action on their request. Essentially, an overview of Point West is a plan development that was approved in March of 1999, and there's been one previous modification to the conceptual plan, and that was about 4 years ago in 2003, and that involves some minor changes to the project. Essentially, it's a mixed-use development. It includes residential as well as commercial uses, a golf course, and has a planned elementary school site within the project as well. And the project is based on traditional neighborhood design principles. This is a view of the zoning map of the Point West project and the area around it. And as you can tell, it's mostly surrounded by a mixture of single-family and multifamily zoning districts. And there's also some commercial, limited amount of commercial properties in the area as well. Looking at an aerial view of the Point West development and the surrounding areas, the development is what's highlighted in yellow on this aerial. And the proposed modifications essentially affect 2 parts of the project. And the first area is the State Road 60 commercial area, which are the parcels on the east and west sides of Point West Drive as you enter into the project from State Road 60. And then the second part is what's called the town center, and this is an area that's essentially the 2 blocks that are just south of the traffic circle or roundabout on Point West Drive, just north of 16th Street. And essentially the proposed modifications to the conceptual plan will increase the amount of commercial building area in the overall development by nearly 30,000 square feet. And this additional building area is divided between both the State Road 60 commercial area and the town center. In addition to adding commercial building area, there's actually a decrease that is proposed for the number of residential units for the development, and that will bring it down by 55 units from the currently approved amount of 1,178 down to 1,123. And this reduction in residential units, the removed residential units are distributed throughout the development. Many of them come from the town center and reflect a reduction in the amount of residential units in the town center. Also, there are changes made with the Central Village, South Village, and East Village. Those changes for the Central Village, South Village, and East Village essentially are to reflect the actual build-out that's occurred in those villages of Point West.
Can I ask a question here?
Sure.
The town centers be reduced, the bottom line on the description and conditions here, from 44 units to 3 units. So that's a net loss of 41. And if we go on the other page there, we had the reduction of 13 units, 2 and 7, comes to a total of 63 units that are reduced total, which we changed those numbers. Am I correct?
Well, actually, the change, there is an approved site plan for the town center, and it does involve 44 units. Actually, what is currently the approved amount that is allocated to the town center on the conceptual plan is only 38. So the reduction on, as far as the conceptual plan is concerned, is a reduction of 35 units.
Okay.
And then, and at the same time, there's also a site plan modification request that's been submitted by the applicant to staff to modify the town center to coincide with the changes that are proposed with this modification to the conceptual plan. And just looking at those changes, no changes are proposed to the requirements that are in place for Point West with regards to building setbacks, landscaping and buffering, the dedications and improvements, and also the traffic circulation. And also no changes are proposed to the approval conditions that were implemented in 2003 that relate to the commercial uses in Point West. And the purpose of those 2003 conditions was to ensure that the commercial uses in the State Road 60 area are consistent with the approved traffic study for the project, and also to ensure that the town center development does not lag too far behind the State Road 60 commercial area. And those conditions are included in staff's recommendation. Essentially, this is a view of the conceptual plan of Point West, which we've already covered. And in summary, staff recommends that the Planning and Zoning Commission recommend that the Board of County Commissioners approve the modifications to the conceptual PD plan with the conditions that are listed in the staff report. And those conditions are essentially the same that were tied to the 2003 modification.
Thank you. Any other questions of staff?
You've got here that before the CO is issued for more than 50,000 square feet of commercial floor area, can the applicant build less than 50,000 twice without coming to you for the second part under your recommendation?
Okay, yes, you're looking at condition number 2.
Yes.
Before the amount of CO'd commercial floor area in the State Road 60 area can exceed 50,000 square feet, a minimum of 25,000 square feet will have to be constructed in the town center.
Yeah.
So that's a threshold that they cannot go beyond until a minimum amount is done in the town center.
Brian, what's your reasoning for that?
Essentially, that condition was implemented in 2003, and the purpose is to make sure to provide a mechanism to ensure that the development of the town center doesn't lag too far behind what occurs on the State Road 60 area, because the town center is more integral to the mixed-use design for Point West.
It's an incentive to have the town center built.
Correct.
Yeah.
The way I read this is the only change we're making is in the town center, we're taking the residential units out of the second floor and making them commercial.
Yeah.
Right. That's it. That's how the increase in commercial area is being accommodated in the town center. Also, the State Road 60 commercial area there's an increase of about 20,000 square feet in the allowed amount of building area, commercial space that
Now, we
is
had a
allowed
problem
there.
with that condominium complex behind that commercial. It's to the west of it. Have they been, do we have to notify them, or, I mean, that was kind of a hot issue to that complex.
Yes, I mean, all property owners within Point West and adjacent to Point West within 300 feet were notified.
Okay, thank you.
So we're increasing the land density area of 20,000 square feet overall.
20,000 square foot increase is occurring in the State Road 60 commercial area.
Oh, no.
Right. But the density is changing now.
Yeah, there is an increase in the commercial development in Point West. There's a decrease that's coinciding with that in the amount of residential units.
Well, those were second floor units. So I'm talking about land density, coverage of the land.
Well, I think it just all depends on, whether they go with 2-story or 3-story buildings. The actual footprint of the buildings may not increase if they go with, 3-story buildings as opposed to.
But the footprint of the commercial area is increasing by 20,000 square feet.
Yep. Not necessarily. Actually, I think the site plan that's been submitted to staff for part of the State Road 60 commercial area is for 3-story buildings. And that's where part of this additional 20,000 square feet is coming from.
Do you have those plans yet? No.
I don't have them here.
Oh, but they have been proposed. I mean,
yes,
submitted.
we have had an application for the State Road 60 area submitted.
Thank you.
But this does not exceed the density approved on the original PD, or TND, actually. No.
It's not
Okay. That's the point I wanted to make.
Chuck, do you all care to be heard?
Or somebody else, if there's anybody else I can close.
Okay.
Please.
The public hearing is now open.
Chuck Meckling, 1999 Point West Drive. I got about a 1-hour presentation, so.
Public hearing is now closed.
Actually, just to answer.
Motions to deny immediately.
To answer the question earlier, up front on the Park of Commerce on State Road 60, we had buildings up there that were going to be more of residential in nature with what we had. And what we're doing is we're taking the same footprint, so the neighbors to the west of us were just aware that all we're doing is changing the usage. What we have found is that right now there's more services that people are wanting in the neighborhood. And we do have a medical building that will be starting in the first quarter of '08 that will be out on State Road 60, and that's going to be in partnership with the hospital. And the nice thing about that is you're going to, and PNS Properties will be doing that, Jerry Swanson, Don Proctor, and the important thing is when we talk, and I mean, Lord knows that Point West has been around for many a year now, but the important point to this is if you want to take trips off the road, you're going to have to allow commercial services in settings that are more adjacent to the residential areas. And that's exactly what we're doing within the planned community, and we're just making an adjustment that's within our traffic study.
Thank you, Chuck.
Thank you.
So move.
Got a second?
Second.
We've got a motion by the rookie.
New guy.
The rookie. The second by the old lady.
Oh.
Whoa.
Whoa. As the holiday season
Thanks
decides.
God we're not elected.
Dead after this meeting, George.
The holiday season.
All those in favor of the motion, please say aye.
Aye.
Opposed, like sign. Carries unanimously.
Move to adjourn.
Next item is Commissioners' Matters. Staff Matters.
Just two quick things, Mr. Chairman. First, just to let you know, Tuesday, the Board of County Commissioners considered changes to Chapter 910 concurrency. I think they were comfortable with all the changes, and most of the discussion revolved around the new provision for permanent concurrency. An owner of a lot could come in and get concurrency for that lot and be permanent. And I think some of the concerns they had were, well, what if you had one entity owning several of those lots coming in and investing for those. So they tabled it until January 8th, and staff will look at options they have to, maybe take that provision out entirely or reword it. And so they'll look at that issue again on January 8th. And the only other item is I tried to email these to you earlier this week, but I think because it was a graphic, it didn't get through. And I passed out to each of you a map that was requested at the last P&Z meeting to show ag-exempt areas inside the urban service area and where our agricultural zoning is inside the urban service area. So we've provided you those maps, and that's the only two items I had.
Thank you.
Could you give street addresses to, or areas where we can find them easily?
I'm sorry?
I mean, the map is all right, but could we have an address or something that we would be able to...
You would like streets labeled? Is that what you're saying?
Right.
Okay.
Or at least the major ones.
If you call him, I'm sure he can show you on the map where to go if you have a spot you want to see. Will, anything under attorney's matters? Mr. Glenn, we have as a reminder, we have to election the first meeting in January, just as a thought. Go ahead.
No, none here, Mr. Vice Chairman.
Nothing there? Okay, I'm sorry, Will. It's been so long since, I forgot that you've moved up down there. Okay, meeting adjourned. Thank you all.